The President, please be seated. The court is now in session. According to our schedule and the notification made yesterday, in today's session we're going to proceed to hear the statement of the accused concerning his character, the questions that will be put by the parties. The security personnel are now instructed to bring the accused to the dock. The chamber would like to now give the floor to the co-prosecutors to put questions to the accused concerning his character. The co-prosecutors will have 1 hour and 15 minutes to do so.
Good morning, Mr. President. Good morning, Chambers. Good morning, Council. And good morning, Mr. Kaing Guek Eav. This is the last time that the prosecution will be questioning you in this case. And so we'd like to thank you in advance for agreeing to answer the questions today. And thirdly, we'd like to ask you to be as focused on the questions as possible and as brief as possible if you can. We've got a number of topics to cover and we would like to finish them within the hour. And the last point before we start, perhaps if we can agree that if you try and open your mind as much as you can as to who you were back 30 years ago at S21, so that you can assist the chamber, continue to assist the chamber in trying to ascertain the truth in your role and in what happened at S21. So firstly, I'd like to follow up with some questions from Judge Laverne yesterday, where he was discussing, or the day before, he was discussing the idea of family. And he was discussing the decisions that you made in relation to forming a family whilst you were working at S21. In response to his questions, he said, you said, "My children were children of Angkar, which were raised to serve the revolution. That was my notion at the time." You then went on to say, and correct me if I'm wrong, but mentally I preferred the whole family loved or were involved in the revolution. So my question to you is, was it your intention that your wife and your children would participate in the revolution, and was it your will at the time that your wife and your children, albeit that they were born whilst you were at S21, that they be a part of the revolution and believe in it?
The accused. First, I still mentioned about the theory, and I still stand by the statement as I already indicated to Judge Laverne. I joined the revolution. I would like my parents to love the revolution, and that one day they too joined the revolution. And I wanted my siblings to love the revolution, and I wished one day they would love the revolution and join it. And to the best of my honesty, I was the cadre of the Democratic Cambodia, and I had no right to get married with any people who were evacuated, or I had no right to get married to the 17th of April people who were evacuated from Phnom Penh. I would like to reiterate that the wife I got married with was the candidate or member of the CPK. She left home to Oral Mountain in 1968, so I got married to the member of the CPK, and I really loved the person in Kampong Tralai. I got married with the person who came from Kampong Tralai, and my subordinates were also recruited from Kampong Tralai. And even Chun Pal was the guy who was raised in Kampong Tralai. And when the children were born, they were the children of Angka. And let's make it clear, it doesn't mean that the children of Angka had to report on the parents to Angka, but they had, as the communist ideology is that they had to be faithful to Angka.
Did you want your children, the children that were born at S21, did you want them to be a part of the revolution? Yes or no?
Response. Everyone wanted the better future of their children. So any revolutionary wished their children to love the revolution and to join in the revolution. And to what the people would view about the revolution at that time was another story.
So you wanted your children that were born during your time period at S21 to be a part of the communist revolution. Is that correct? Response. S21 was part of the work of the revolution. So I did not aim that my children would become the police as his father would have been. But we would like him to be part in the revolutionary line, after all. Thank you. You got married you met your wife in 1974, and you got married in December 75. You had your first daughter on the 27th of April 1977, and you had your first son on the 14th of December 1978. So during that period, you obviously believed in aspects of the revolution. You may not have agreed perhaps with some of the way in which it was being carried out, but you believed in the revolution. You believed that what you were doing at S21 was a means to an end. It was a way in which you and others could achieve the communist revolution and create this new society as you had planned. Is that correct?
Response. I have already repeatedly indicated in relation to this matter. If we refer to the revolution notion, I think I actually did not really like the police work. However, I was in or amongst the candidate members or the members of the party who had nowhere to escape. So I already indicated that we were the actors of the crimes and trapped in the system. As Mr. Raul Chena already mentioned that I should have said that I was the servant of the regime. And Madame Cerrone Guilbeault already stated that I was part of the gear of the machinery. And I would like my children to be part in the revolution, but although I knew that it was part of crimes, but I could not escape. I never envisaged that CPK would be defeated any day.
So is it fair to say that you believed in what you were doing, you believed in the revolution, but you just didn't like the idea of killing and torturing? Would that be fair to say?
Response. I think these issues cannot be separated. They are very interrelated. Before 1971, before I received the task as the police, I really trusted the party. However, later on, when I had learned that people had been executed, I started to feel suspicious. And I started to realize that this is the way that the revolution would be leading to, slowly but surely, but I really don't expect that the execution could take place.
Why would you bring children into a world where you believed that crimes were going to be committed and where you believed that possibly you might be implicated in the regime, and if you were implicated, your family would be implicated? Why would you bring children into the world if in fact you believed that would happen to you?
The President, Mr. François Rouge, you may now proceed.
Monsieur le Président, pardonnez-moi, je trouve que c'est une question.
Mr. President, forgive me. I think that this is a borderline question, which is of a nearly intimate nature, and I do not think that it has its place in this debate. To ask someone why they procreate, please excuse me, but this is infringing on privacy. And I would ask that the prosecutor perhaps reword his question.
I'm not quite sure I understand the basis of that objection. However, Your Honour, I can put the question in another way. Whilst you're at S21, you felt secure enough in your own safety that you would not be implicated. Otherwise, you would not have had children. Is that correct?
Response. Regarding the implication, I think it is more about the assumption rather than the reality. How could we conclude the situation whether I would be implicated during my work at S21? But in reality, my soul was at the tip of my hair, or I was in fear anyway. My brother-in-law was arrested and sent to live with me, and another brother-in-law also was arrested, and my superior Won Wait, Khoi Thun, and other close friends of mine who were the head of the zones were also arrested. So I could not envisage when exactly I would too be implicated in the confessions of the people arrested, because I noted that some already implicated Son Sen. So he too could probably envisage that he would be implicated. My wife was removed from the hospital, and as I really wanted to have children. So if I did not die, then I could really build a family. And if we died, we died. Our family altogether would have been executed. So if I died, everyone in my family would also die.
You said that you were trapped in the Khmer Rouge regime, but let's be clear. At the end, everyone was trapped. I mean, Von Vet was on the standing committee. Sun Sen, you say, was implicated. Everyone in the regime, including Pol Pot, was subject to being implicated and subject to being taken into S21. Do you agree with that?
Response. People who were not implicated were respected. There were Pol Pot and Nuon Chea. They were not implicated in the confessions. Sao Phum was implicated and died. Tamok, the fourth individual, was also implicated, but no one would dare to arrest him. Ieng Sari was not implicated. The sixth person was implicated and died. The seventh individual, Son Sen, was also implicated in several confessions. Khieu Samphan, probably the eighth individual or person, was not implicated. So it is about the implication. And this is what I can recall. So I have no idea who else would have been implicated.
Perhaps if we can go to some of the traits that you displayed at S21, and one of those was perhaps, and it's been seen through the evidence, is your will and desire to accept the job, and the pride that you displayed at S21 when carrying out your job. Would you agree with me that the education and training role you had at S21 was the largest role that you've ever had in your career, and it was a valuable role to you because it related to training and teaching in ideological indoctrination, not just maths, but something that actually changed people's lives, changed society. And that aspect of it, and the fact that you were in charge of the central interrogation centre at S21, that made you feel good, that made you feel proud, and it was a very big opportunity for you, a man with a lot of ambition. Would you agree with me that when you first took on the job at S21, you were proud about that fact?
Response. Honestly, I was not proud to be accepting the assignment at S21. I was there at the beginning as the deputy chairman. On the 3rd, on March 1976, when Nat was removed and I was promoted to the chairman position, and I contest or I challenged the position. I would like Chai Kum Ho to take the position. However, I was warned by my superior. So this shows that I was not proud about that. The remaining documents can also be sought to support these arguments, because the document under E5/2 from point 1 to point 8 are the documents during the time when Nat was in position, and what annotations or writing I made in relation to those documents and what kind of writing I wrote later on. You may refer to them, that I was not proud about being offered such position. Coming to the education.
Perhaps I would like to put some particular examples to you, so perhaps if you can wait for that moment to explain about whether you are proud in your role as an educator. Maybe the word is not proud. Isn't it the fact that you felt satisfied? You felt satisfied that you got the position because you felt that you were better than that. You were a better interrogator. You were a better educator, and therefore you felt that that position was more rightfully yours than Nat's. Would you agree that you were satisfied of that fact?
Response. It is not correct to say that I was satisfied, but it would be better correct if you put it this way, that I was good at pleasing my superior. Although Nat was my superior at that time, his theory was not that good as mine. So I had the ability to please others better than Nat.
And the fact that you had the ability to please others better than Nat, namely pleasing your superiors, that made you feel good because you were ambitious and you were working together with the highest level CPK leaders in the country. That made you feel good. Do you agree?
Response. Your assumption is entirely accurate, but you should also look at the other aspects of the situation, because I frequently or regularly made phone calls to my superior every evening. So if he ordered me to do anything, then I had to fulfill his orders. So please balance this.
We understand that you and everyone else in the Khmer Rouge period was working under a system of orders, but the question is, of course, is whether or not people wanted to deliver those orders or whether they objected to them. But we'll discuss that in a moment. But perhaps I would like to put a quote to you that Judge Cartwright put to you in testimony the other day, and she quoted from David Chandler's book, and she stated, she summarised the book, "You wanted to excel at your job at S21. You thought you were doing an excellent job. You wanted to excel right throughout your career, from the time you were a student. You wanted to serve your superiors with enthusiasm and skill, and you wanted to be proud of your work. Is that a fair assessment of your character?" And you responded, "Your Honour, talking about wanting to be in that role, indeed, yes. But I do not want to say the reason for my wanting to be such a person at this stage." So bearing in mind what you've said earlier, isn't it the case that when you first started at S21, as you have said to Judge Cartwright, you wanted to be in that role? Things may have changed later. Things may have changed later in 1978 when your superiors and friends were being arrested. But when you started at S21, as you've said, you wanted that role. Can you explain why you wanted that role?
Response. Mr. Co-Prosecutor, your question is difficult for me to respond because through the layers of interpretation in the Khmer transcript into English, and now you speak in English. I do not know how appropriate it is from the English transcript, and I now listen through the interpretation in Khmer. I think it would be appropriate if we look at my personal transcript before the chamber, and then we could put the issue before this chamber for confrontation.
I'm not sure whether there is a translation problem. However, we can discuss the matter in another way. Judge Cartwright also put to you another quote. She said, "You are intelligent, well-educated, you work hard, and you were enthusiastic. You would like to please your superiors. You wish to be professional in everything you do. You are meticulous in your work, pay attention to detail. You are proud of the work that you have done. Is that a fair summary?" And you responded, "I do not object to that statement." What aspects of your work at S21 made you proud?
Response. The word pride, being proud, has been discussed extensively previously, and also you agreed not to use that word. We agreed to use the word that I tried to carry my duties in order to satisfy my superior, and we agreed on that. So I would like to make a conclusion that within my capability in using force, kicking, beating, for instance, I did not have that qualification, but equipping someone with education, with doctrination and theory, yes, I was capable to do that. First, to satisfy my superior, and once my superior was satisfied, I would be spared. And I did not push myself for promotion into the Central Committee. So this is not a pride. It is the endeavor on my part to satisfy my superior so that I could live and see the sun. That is all.
The word pride is a word that, in fact, you have used throughout this trial. You've said that you were proud when you discovered the high school, the Tulslang High School. You said that you seemed to be a bit proud when you were speaking on the microphone at your training sessions. You also said that when you met Pol Pot in the last half of 1978, you also said that he made you feel good. And perhaps if I can quote what you have said to this chamber, you mentioned earlier that I questioned you and you answered, the question was, you mentioned earlier that some party members would be jealous if other party members met Pol Pot. Did you consider it a privilege to be in Pol Pot's presence at these meetings? You answered, I would like to frankly state that, at the time, I had a very strange feeling that I studied with the 7 people in the party for 3 years now, and I meet the first person in the party for the first time. And I had a very strange feeling, but it's hard to describe that feeling at the time. I asked you, did it make you feel good to be in his presence? And you said, the strange feelings mean, you know, the good feeling. So my question is, why are you feeling good in the last half of 1978 when you believed, or you have told the court, that you felt the regime had got out of control, that you didn't believe in the revolution anymore, that you hated your job, that you were in fear of your life? How can you feel good when you meet the person that you believe, with others, is making all of this happen? Can you explain that, please?
Response, Mr. Co-Prosecutor. Your question is long, but to sum up with, it would be on the day that I attended a training where Pol Pot delivered his speech. Every year, I did not attend the meeting with Pol Pot. It was always with Son Sen, but only that year when soldiers were sent to the front, and Son Sen did not open the training in Phnom Penh, so I attended with other people, whereby Pol Pot delivered his presentation. So to sum up, I did not attend the session with only 7 persons. There were hundreds. Pol Pot was present delivering his speech, and Nuon Chea was there next to him. Hundreds of attendants at a time. What I was excited about was, first, I attended the training with the first person, not with the 7th person, but the most exciting part was that Pol Pot did not allow for interrogation, and that was absolute. Stop interrogating people. He also said the word bandits were those who starved and who stay in the forest. So if they were fed, there would be no longer no bandits. And I was happy with that statement because there was a previous circular on the people who attended the CIA and Wajir, etc. And I was happy with such statement. So when I returned from the training, I did not ask people on that because that was the speech by Pol Pot. And Nuon Chea asked me later that Duch now knew more about the party line, and he still instructed me to interrogate again. But at that time I thought the interrogation was over because that was advised by Pol Pot, and I was so happy at the time. And that was my feeling, and this is my response, Mr. Co-Prosecutor.
At that time, you still believed in the communist revolution. You still believed that the revolution would succeed, and you were pleased to meet the leader for that very reason.
Response. Talking about attending the training is a separate matter. Meeting with various leaders is another matter. I never met any other leaders except Noon Chea and Son Sen, and I saw Pol Pot once during the training. So you had to separate the matter between attending the training and meeting with the leaders. I never met those leaders besides the ones that I just mentioned.
At the time you met Pol Pot in late 1978, you still believed in the ideals behind the communist revolution. Yes or no?
Response. Mr. Co-Prosecutor, the matter of believing something or not, I told you already in the past, belief is accumulated in its nature. In myself, partly I believed the ideal, but another part that I was doubtful that it's not going to succeed. And when the statement by Pol Pot talking about stopping the interrogation and torturing, then I thought, oh, now they would return to the proper path. And that I was happy. But if I was lied to by that statement, then I would be disappointed. And that was the situation at the time. And that was what we were trained and instructed. The President, François Roux, you take the floor.
Mr. Roux, Mr. President, I am sorry to interrupt again, but I'd like to call on my learned friend to put questions rather than putting forward hypotheses or statements. Instead of saying to the accused, you had faith in the mission, yes or no, you should say, did you have faith in the revolution instead? Because you have put several questions where you put forward an idea and then you ask the accused to accept your idea. Please be so kind as to put questions for him. Don't ask him to agree to your ideas. These are closed questions, and I do not believe that these are acceptable in your system.
Your Honour, if I can briefly respond, there clearly were questions. The accused clearly has an option whether to agree to it or not. The questions are based on evidence that's in the case file. It's based on testimony. As you know, Your Honours, the defendant speaks at length with open-ended questions, and it's quite appropriate and quite proper, I submit, that questions such as yes or no serve the purpose to assist us in finding out the truth in this matter.
De contribuer à une manifestation de la vérité dans cette procédure.
The President, the Chamber has noticed that it is difficult in dealing with the questions to be put by the prosecutor because the questions are long, and we have noticed the objections raised by the Defense Counsel on 2 occasions already, and from what we have noticed, these are leading questions. Therefore, the co-prosecutor, you are instructed to rephrase your questions, simplify them for appropriate response. Therefore, it's better for you to ask several more questions rather than a few long questions.
Thank you, Your Honours. I'll adopt that approach. During this trial, you have explained at length the efforts that you went to in order to ensure that your interrogations led to the implications of enemies. You have explained that you would get innocent young men, you would indoctrinate them, you would educate them, you would train them in torture methods, you would dare them to be cruel to such a point that the confessions would produce names of enemies, of which most of them you knew to be false. You forwarded them to your superiors. When those names were forwarded, you've testified that your requests for arrests were always approved, and those innocent people were subsequently arrested and killed. Would it be fair to say that you exercised your power at S21 to the maximum when you were the chairperson there?
Au maximum pendant la période où S21 était sous votre direction.
Response.
Réponse.
Mr. Co-Prosecutor,
Monsieur le co-procureur,
before you put a question to me, you described the works that I did using additives at your own will, which are not the additives I used in my statement. Therefore, I would like to make my statement clear now. It is my preference to recruit the poor peasants' children, to educate them because of their class stance, of their loyalty, and that they are not influenced by any other factors. For example, the Chunpal is a case. And when they arrived, I would assign them the duties. For example, the guarding duty, the interrogation duty, etc. So that was the practice, and that's what I mentioned in the past. Regarding confessions, I repeatedly stated that my crimes were not that I directly executed those people, but it was my crimes that I built those people up to interrogate. And if I built 10 people who were loyal to the party and who were meticulous with the same types of work that I did, then the crimes would be more widespread, and that was my crimes. Another crimes were that I rejected their stance, their ideas and notions, and I indoctrinated them with my own notion, with my own idea and methodology, and that they have to accept what I wanted them to accept. And I think the same practice is applied for the current interrogation process.
If I can just stop you there and put to you a statement that you made to the co-investigating judges, and it's 00149918 at D21. It's a statement that you made in relation to the stances that you took when you were at S21, and you stated, at S21, I evaded work to the maximum. I accepted only the work that was unavoidable. I thus never grasped anything. Would you agree with me that with the evidence that you've given at this trial, that you misled the co-investigating judges by saying that I evaded work to the minimum? Would you agree with me at the time you misled the investigative judges as to your role at S21 when you made that statement?
Les enquêteurs quant à votre rôle réel à S21.
Response, Mr. Co-Prosecutor, would you be able to show that statement with the co-investigating judges in the Khmer language and also the transcript in the Khmer language to be put before the chamber so that I can examine them?
Perhaps it would be easier and quicker, Your Honour, if you could just comment whether or not that statement is true. At S21, I evaded work to the maximum. I accepted only the work that was unavoidable. I thus never grasped anything. Is that statement true?
Response, I do not understand your question, Mr. Co-Prosecutor, so I cannot respond appropriately.
Your Honour, I can't pull it up on the screen now.
The President, Kasavut, you take the floor. Kasavut, Mr. President, I would like to request the International Co-Prosecutor to have precise questions for the accused. For instance, if you were to say that my client has not confessed fully to his activities, then you can pinpoint which actions or activities that he has not yet confessed, and then you can provide the statement or the excerpt of the statement he made before the co-investigating judges. The President, the co-prosecutor, if you relied on the statements made by the accused before the co-investigating judges, can you clearly state which language of that statement, and can you tell us which paragraph, on what page, and what is the ERN number, so that the chamber is able to protect that portion of the statement, so that the accused is able to examine and respond appropriately. And you are reminded by the chamber that the proceeding before this chamber is part of the overall proceedings, and the statements made during the investigation phase is just part of the case filed. So the statements made by the accused has been stated so, and he made several comments on his statements before the co-investigating judges. So I think it could be different relying on the documents during the investigation, because during the trial phases he made additional comments to those statements that he made previously before the co-investigating judges. So it would be better if you can provide the excerpt, a portion of the documents that you rely upon so that the chamber is able to have it shown before the chamber, and that the accused has the capability to review it and to respond appropriately.
Thank you, Your Honours. Perhaps I will move on from that, but I will give the ERN number of 00149918 D21 in the English, and perhaps that can be assessed at a later time. Mr. Kaing Guek Eav, for the time that you were at N13, from the time you were at S21 to the time that you say that you were still a prisoner of the regime, can you tell the court when you felt that you were not a prisoner of the Khmer Rouge regime anymore? What year, please?
Pouvez-vous nous dire, selon vous, en quelle année cela a eu lieu?
Response. It was on the 10th of May 1999. At that time, the government detained me at the military court.
Prior to 1999, were you free to move across, or were you free to move out of the Khmer Rouge area prior to that date?
Response. Before 1999, I think you already know the situation. In around 1997, Mahmoud gathered up the people at Samlot and put them at a camp. And anybody who were to leave the camp would be risking their lives. And they returned in 1998. I was scared of Duch's force. And if I were to show my face as I was the chairman of S21, I would be beheaded. Of course, I could move freely, but that was the concern that I had at the time. Duch was a Khmer Rouge. That's why I said the criminal regime against the humanity ended when Duch was arrested by Hun Sen and detained at the military court.
So are you saying for about 26 or 27 years from 1971 that you had no possibility in all of those years to escape from the Khmer Rouge? Is that what you're saying?
The accused, could you please make a proper mathematical calculation? Yes, I think so. The duration is correct. I was under the detention of the Khmer Rouge regime, although it was in various different forms. The co-prosecutor already knows. I stepped a little bit out of the proper way, and my wife was killed.
Is it not the case that you stayed with the Khmer Rouge regime up until the 90s because you still believed in it?
Response. I think it's kind of appropriate if you put it that way. Of course, by that time I totally do not believe in their ideal anymore. By that time, I did not work at the battlefield. You can ask. The governor of the Samlo district, Mr. Supal, wanted me to be with the transportation unit. And later on, I was asked to teach at a primary school and accepted that job. So I was with them in person. But whatever services to provide to the battlefields or to kill people, I denied those requests. So from the 17th April, from the 7th January 79, yes, I dare to object to the request for me to involve with any battlefield or with any killing. And this is my response, Mr. Co-Prosecutor.
When you spoke to the psychologist, you talked about your father's death in 1990, and they stated in their report, talking about his father's death in 1990 and how he felt at the time, you said, "I could not be a revolutionary and also have feelings." Is it not the case that in 1990 you still were a revolutionary, you still believed in the regime, and that's why you stayed with the Khmer Rouge?
Response. I think the analysis of the experts have taken me by surprise. And it is now the matter that I am not in agreement with the assumption or analysis by the experts. Anyway, so you should be familiar with this.
Many of the experts that have reviewed the documents in the case, especially the documents at S21, David Chandler, and also the psychologist, have stated that the reason why you obeyed the orders was not only out of fear of not obeying them, but because you believed in the underlying basis of them. And if I can put to you a section of the report from the psychologist, and it states, "Obedience was not the motivation for his acts, but a consequence thereof, because he needed something in which to believe. Also, he was driven by fear, in brackets in 1977, and by the idea that he was better off continuing in his job rather than walking away from it." Isn't it the case that you carried out the orders at S21 because you believed in the revolution, not just because you were ordered to carry them out?
Response. Mr. Co-Prosecutor, I would like to state that the analysis of the expert is another case, and in reality, what I have experienced is another case. I would like to tell you the reality and things that I have done. And I believe that the documents remain. Documents of S21 remain, so you may refer to them. And I did everything not at will, upon the orders of my superior, because every day the confessions would have to be reported to Son Sen, and I was closely monitored. Whether I like it or not, I had to do, otherwise I would be killed. And this is just the reality as opposed to the analysis by the expert.
Just a few questions about your arrest. You stated in court that whilst you were preparing yourself to gain a promotion to be the chief of the Education Department of Samlak District, that essentially your future was changed by Nick Dunlop. You stated that everything was compromised when Nick Dunlop found me, and later I was arrested and put onto detention at the military court on the 10th of May 1999. My question is, if it wasn't for Nick Dunlop approaching you, showing you the photograph of you at S21, and you knowing the fact that he knew of your role there, you wouldn't be in this court today. You would be teaching as the chief of the Education Department at Samlak District. Would you agree with me on that?
Response. You have stated, and in your statement, you included the Nick Dunlop, but I may have to explain to you the accounts of what happened now. I already indicated to the chamber already that when Su Maid surrendered and defected to the government, my youngest brother wanted me to live with him in Swai Chek. So the Ham Sapal Su Maid and General Nham Kung convened a meeting, and that they convinced me to defect to the government, or integrating into the community in some load, and they installed me as the chief of the education department at some load under the supervision of the government. While we were preparing for this, then Nick Dunlop approached me, and everything was compromised, and that is true.
So you had no intention for handing yourself over to the authorities until you were confronted with your past acts. Do you agree?
Response. I may not have to say that I agree with you, but I would like to elaborate as follows. I already indicated to the chamber, I think that no secret could be hidden forever. One day the secret can be compromised. In Ban Thi Mien Chey, I was acknowledged, recruited as the school teacher, but in 1996, in March, Ieng Sari integrated into the government, and I asked him to also accept me to join the government, but Ieng Sari didn't recognize me. Then I asked in favor for Su Maid so that I could be presented to the government. I sought, I found a channel so that I could be introduced to the government. That's why I asked Su Maid so that I could be integrated. Then I had no intention to escape from joining the government.
Just a few questions about your apologies. And in response to Judge Laverne's question the other day, you testified that in relation to the crimes at M13 and S21, you believed that the party centre would be responsible before the history. You testified that you told Peter Lauprecht the same when you were in the military court. However, when you met your two lawyers, and I assume that you're referring to the two lawyers here today, after my consultation with them, I agreed that this work was not a responsibility of the government because the government would not be responsible for criminal acts. And it was the individual who would be responsible for his own criminal act. But in my mind, I was still believing that I was a policeman who was carrying out the order assigned to me by my superior. And this is how I developed my mentality regarding the crime and criminal responsibility. My question is it fair to say that you've only accepted individual criminal responsibility or individual guilt since 2007, since you met your two lawyers as you explained to the court?
Response. I may have to reiterate the account of the story based on the facts. Actual fact. When I was assigned as the chief of the police at M13, Chai Kum Ho told me that as the chief of M13, or M13 was not in charge of arresting people, and I was assured that I should not be worried because the party would be responsible. And I was reassured by him every now and then. However, when I noted that more and more people were being arrested, and I also made it clear with Peter Lepridge, and I believe that Peter Lepridge also recorded the interview, although I did not notice any camcorder that he was brought with him. And I told him that the CPK government was the legitimate government in the eye of the United Nations. And if I did not follow the government, then I would be executed. So what had I done wrong to obey or to follow suit the order of the government? But then people told me that this government was the criminal government, and as part of the government, I shall be individually responsible for the crimes I committed alongside with the government acts.
Thank you, Your Honours. I think my colleague has a few questions.
Co-prosecutor, good morning, Mr. Kaing Guek Eav. Do you know that In Lawn, alias Nat, was removed on March 1976? And do you know the reason why he was removed and where would he be sent to? Response. Thank you, Mr. Co-prosecutor, for putting this question. In Lawn, alias Nat, was removed on the 3rd. Mr. Francois Roux interrupts. The President, Mr. Francois Roux, you may proceed.
Monsieur le Président, je crois que nous posons normalement...
Mr. President, I believe that when we are in the process of asking questions addressing the character of the accused, I don't see what this question has to do in any way with the character of the accused. I would like us to return to the subject matter of today.
The President, the objections sustained. So the co-prosecutor, could you please revert your questions so that the questions are related to the matter of the character of the accused as scheduled in our today's session. Co-prosecutor, thank you, Mr. President. The prosecutor noted that this question may lead to the follow-up questions, so we would like to proceed to the next question. Then, have you ever felt that you were jealous with In-lawn alias Nat because you were the deputy to him at S21, and you already indicated to the chamber that you was the chief of the focal points network and that Nat was the member of the team, and at that moment Nat was the chairman instead, and you was the deputy. So were you jealous? Response. Honestly, In-lawn alias Nat was older than I am, and as you have already observed, that I already paid homage to two people, and Stephen Hessel and Madame Mirkate Samport, and I respected them. Although In-lawn was my subordinate previously, but I did not really violate the rights of him being promoted to the chairman. And when I was at the S21, and as the co-prosecutor in Cambodia have already been familiar that the CPK status have been well given to the military, and In-lawn alias Nat, Sambat and Miss Mut were the three important people to be installed in the military, and I was not jealous. And during the meeting of the branch, which was convened at Office 505 in Piem Commune, I could see how important their roles were, and I was not jealous at all. And as I mentioned already, I was not satisfied with the role at S21, and having had In-lawn as my superior, I was already happy. The prosecutor, after 1979, have you still been faithful to Son Sen? The accused 7 January or 7, the prosecutor 7 January of 1979. Respond. Thank you, Mr. Co-prosecutor. It is the moment I really am waiting to reveal the truth to the world and Cambodia. I was very shocked when enemies implicated him. I was very worried for him. When I was called to meet in office 18, I was reassured that I should forget the past. And I could see that Son Sen had been still very faithful to me and been caring for me. That's why after the 25th of June 1986, I still had very great respect and faithfulness to him. The co-prosecutor, thank you, Mr. President. We do not have further questions to put to the accused. The President, since it is an appropriate time to take an adjournment, the Chamber will take the adjournment for 20 minutes and resume accordingly.
The President, please be seated. The Chamber is now back in session. For this afternoon proceeding, and as I already informed parties to the proceedings, is that the Chamber will hear the submission by the parties on the request for admission of additional materials which are not included in the submission of those documents during the proceedings up to today. And in order to facilitate the process, the submission has to be clear on the remaining and pending documents and the new additional documents that are sought to be admitted. Also, it has to be clear on the identification of those documents. And regarding the new documents which are sought to be admitted before the Chamber, have to have clear identification so that parties can examine those documents before the Chamber makes its decision whether they are admitted for review or examination before each Chamber. And I would like the co-prosecutor now to start with this proceeding if they have additional documents to be requested.
Your Honours, I stand before you in all humility, in recognition of the fact that today you have completed hearing of evidence in this momentous exercise of finding justice to the Cambodian people in this trial, which has been created on the intersection of national and international laws. This court has been created on the intersection of the desires of the national and international communities to get justice, albeit delayed, albeit at some cost. So I realize the momentous nature of this day when you have finished hearing evidence. And I have this onerous task to bring before you certain further documents that are already on your case file that may or may not be to some extent referred to during the trial that you have heard for these more than 6 months. But just so that a historical record is made of the crimes that occurred as S-21 and of the background and the context in which those crimes occurred at S-21. In the proceedings that are before you, you have led the examination of witnesses, quite appropriately so, because you are the trier of fact. You are searching for the truth. And so were the investigating judges when they examined as neutral and impartial investigators evidence that was brought before them either by parties or that they independently gathered. At the same time, the rules that your honors have given us from your plenary casts a burden and onus on the office of the co-prosecutors to prove the case beyond reasonable doubt under 87(1). And what I'm going to do today is not to burden you with further documentation, but a very sincere request on the basis of analysis of all the documents that you have seen or heard in this trial to essentially complement those documents with certain further documents that will make your exercise of judgment a bit more easy. And as we call it in criminal law parlance, you will have the best evidence before you. I have mentioned in my opening few sentences that this court has been created as a marriage of national legal procedure prevalent in Cambodia with that of international standards adopted at tribunals such that are trying crimes of magnitude and complexity as this crime. Therefore, while the national courts of Cambodia in their ordinary municipal jurisdiction would accept the entire case file as the case file for reliance at trial and for their judgment. However, quite appropriately, because of the specific, complex, and a very big nature of these proceedings, where crimes in the nature of hundreds and thousands of individual criminal acts are being prosecuted against an individual for a period of 3 years, 8 months, and few days, it's quite appropriate that complete documentation is before you to assist you at judgment. And this exercise at the end of trial, when we have been able to make a tentative evaluation of what has come before you and what may further assist you in your judgment, is to that effect to give you access to the best evidence such that the making of judgment is facilitated, is made easier for you. After all, we deem this as our duty under 87(1). While creating those internal rules and granting us this burden to discharge, you also said under 87(2) and 3 that certain documents can be brought before you, can be put before the chamber, can be subjected to examination, so that there is a sifting mechanism, a filtering mechanism, and you focus yourselves in your judgment only on key facts at issue. That has also been helped by my learned friend and his client in admitting certain facts in the agreed facts that they have provided to your court. It has also been helped by some cooperation that this accused has demonstrated. So this background is essentially to tell you that what I am going to embark upon is not an exercise of lock, stock, and barrel putting material from the case file before you, but a very sincere and methodical exercise to bring certain more material that complements and may also supplement the material already before you. Now, in respect of these 4 heads of materials that I'll address, Your Honors, we have had some preliminary discussion with my learned friend, Mr. Ru. He, in his usual magnanimity, has said certain things to us which I wouldn't want to say, and I'd let him say. So I will essentially bring these documents before Your Honors and let my learned friend respond. Should he have major objections to those documents, I shall revert to them in detail in respect of why they should be taken on record by Your Honor. Now, with that background, let me begin in respect of the 4 sets of documents that we wish to bring before you, that we wish to put before you, so that you use them at trial. The Your Honors have, over a period of time, adopted a certain methodology as to how they should be put before you. Your Honors, in a decision in a trial management meeting on 11th of June, said that it could be treated to be put before Your Honors if it's appropriately identified. And then Your Honors elaborated by saying appropriate identification does not mean reading it aloud in court or even reading its summary, which may be necessary at times, but essentially identifying that document, the name of that document, the ERN number of that document, and certain such other things that very clearly puts it on record. And in my next few minutes of submissions, I shall attempt to do exactly that. Now, as I submitted, all these 4 heads of documents are before you in some form or the other. One form has been under Rule 92, which once again, Your Honors, rules permit us to bring written submissions throughout the trial till the closing submission, to bring to your attention either evidence or arguments that we wish to canvass before you. So we have adopted that mechanism, which in our most respectful submission is quite permitted under the scheme of the rules adopted by you. I shall begin this exercise in the very beginning. The first document, and indeed it's a map that we wish to bring before you, is a map that the learned investigating judges annexed as Annex A to their indictment. This has been clearly on the record before you since the time you received the indictment as confirmed by the pre-trial chamber on the 5th of December of 2008. Clearly, there are no 3 ERN numbers for this. There's only 1 ERN number for this map. And I can demonstrate to you that map, which has been very helpful for the Office of the Prosecutor in evaluating evidence. It gives a complete pictorial description of S21 and its vicinities. It is at ERN number 002-10940, and this is Annex A to the indictment received from the learned co-investigating judges. The second item that I wish to bring before you, and I will give a 1-minute background to that, Your Honors, is a document that we filed on the 29th of April before your court. And this document essentially pertained to the establishment of the existence of an international armed conflict throughout the jurisdiction of this court on the territory of Cambodia, between Cambodia and Vietnam. Now, this accused before you has admitted in the agreed facts of the establishment of an armed conflict between Cambodia and Vietnam between 31st of December 1977 till the end of the temporal jurisdiction of this tribunal. While agreeing with that, it is the contention of the co-prosecutors that indeed an international armed conflict existed between Cambodian armed forces controlled by the Khmer Rouge regime and the forces of Vietnam during the entire temporal jurisdiction of this tribunal. My learned friend, in his magnanimity and usual generosity, has not denied that there was not an armed conflict between 1975 and end of 1977. He has left it to your honors, in the light of evidence before you, to determine whether there indeed was an armed conflict between April 1975 and December 1977. Your honors would recall the expert witness, Professor Dayan Chanda, mentioned in his testimony that indeed an armed conflict existed throughout the temporal jurisdiction of this tribunal. Therefore, the documents that we wish to bring before you and that we brought before you on the case file on the 29th of April 2009 in the form of the document E61 and its attachments are those documents that we wish to put before you so as to assist you to conclude that there was indeed an armed conflict on the territory of Cambodia for the entire temporal jurisdiction of this court. Now, those documents are contemporaneous documents, some of them created by the DK regime, some of them communiques of neighboring and other governments and the United Nations, some of them magazine and newspaper articles, which, in the absence of a witness before you who has seen all those events, in our most respectful submission, is the best evidence that should assist you to conclude that there was an armed conflict on the territory of Cambodia. Those documents are added as Annex A to our filing E61 of the 29th of April 2009. And just as His Honor the President directed me, I shall give you the ERN numbers first of our filing and then of the Annex A that consists of the documents attached to that filing. Bear with me for these ERN numbers, Your Honors. The English version of this document of 29th April 2009 bears the ERN number, and I shall be very slow, 0032 6308 to 0032 6309. And this document reads, Rule 92 Submission, Notification of Armed Conflict Documents to be put before the trial chamber pursuant to Rule 87.2. The Khmer version of this document bears the ERN 0032 6310 to 0032 6312. That's the motion supporting the annexes. And I shall now read the annexes. Annex A bears the ERN 00333 to 00333 141 in Khmer. In English, it bears the ERN 0032 6313 to 0032 6348. Our discussions with my learned friend on this armed conflict documentation resulted in the observation of my learned friend during the proceedings of this court on 19th May 2009. And I read from those proceedings at page 67 in English. And my learned friend said, I told the office of the co-prosecutors, give me a one-page summary of these press articles. But I was dreaming. My dream would have been that the office of the co-prosecutor, instead of putting all these press articles, would select the most important ones and put them. If I were to understand my learned friend's observation correctly, although he would have preferred those documents, those press articles from various newspapers around the world, some of them in English, some in Khmer, some in French, and some in 2 or more of those languages, the best option would have been for us to have translated all those press articles into all the 3 languages of the court. But the other option that he so magnanimously gave us was to give him a summary of those documents. We would most respectfully submit that our submission just now be deemed as a summary of those documents, except if my learned friend still deems that we need to satisfy him further, we would be very happy to do so. This was the second submission, Your Honours. My third submission pertains to the documents that are attached to our filing, a more recent filing of the 19th of August 2009. And this filing, in English, I may read so that it may be translated for the benefit of others present in the court. Co-prosecutors request for the admission of relevant testimonial statements and annotated S-21 documents collected during the judicial investigation. This document, following Mr. President's direction, bears document number E152. Its ERN in English is 00364635 to 00364649. In Khmer, its ERN are 00364650 to 00364672. Now, this filing of the 29th of April, of the 19th of August 2009 has 4 annexes. Annex A, and once again I must submit that all these documents were obtained, subjected to test and examination by the learned co-investigating judges. First is Annex A, which consists of statements given by this accused before the office of the co-investigating judges. It also includes records, written records of confrontation that the learned investigating judges organized, and the written records of the reconstruction that was mentioned this morning, once again prepared by the learned co-investigating judges. Annex B to this motion consists of witness statements, once again taken by independent, neutral, and impartial investigators of the learned co-investigating judges during the judicial investigation that have been available to the parties since the time they have been available to the co-prosecutors. Annexes C and D of this document of the 19th of August 2009 are about 60 such documents on which this accused, during his chairpersonship of S21, made annotations. A lot of these documents were used by investigators of the investigating judges to put to various witnesses. A lot of these documents were put by the co-investigating judges to this accused. A lot of these documents were put in this chamber to this accused and to other witnesses for their comments. In our respectful submission, these documents go to the very core of the issue before you, and which is the role and the extent of participation of this accused for the crimes that are charged against him. They were contemporaneous documents prepared by or under supervision of this accused, which he signed and annotated without fear of criminal prosecution and in his exercise of full authority as the chairman of S21. Therefore, they shall be of greatest assistance in our most humble submission to your honors in concluding the extent and the nature, and if at all mitigation is called for, of the responsibility and the punishment that should visit this accused. We have also had a discussion about that with my learned friend, and I'll leave it to him to respond to you on what he thinks about these documents. The last set of documents that I wish to bring before your honors, in fact, it's not documents, it is a document, is a book. And this forms the basis of our filing of 24th of August 2009 before your honors. This filing consists of a motion which is numbered 00369927 to 00369928, and in Khmer to 00369929 to 00369930. This document was described as document number E160, and it's entitled Co-Prosecutor's Notice to Place Nick Dunlap's book, The Lost Executioner, on the case file and for its admission as trial evidence. We made extensive efforts to find this book in French also. Unfortunately, and actually the author conceded to us that he also felt that that was unfortunate, it is not available in French. It is only available in English and in Khmer. This book, your honors, was extensively referred by the learned co-investigating judges. The accused was asked questions about it in the judicial investigation, and so also during the trial before you. In our most respectful submission, this book gives the most complete account of the activities of the accused post Khmer Rouge regime, that is post January 1979. The accused, as he told the learned investigating judges, has read this book, and this book, in our most respectful submission, should be before you, especially when, as my learned friend claims, the whole issue before this court is whether there should be mitigation for the remorse and the apology and the admission of guilt demonstrated by this accused. The ERN numbers of this book, as placed on the case file, are as follows. In English, and the entire book is on your record. In English, it is 00369932 to 00370 In Khmer, it should be 00370 271 to 00370 539. Now, your honors may tell me, and I ask this question to myself, should books, lock, stock and barrel in an entirety be put before chambers, and should they be burdened upon the judges in their evaluation of evidence? Your honors, we would submit that this would be an exception. This book is written by this journalist who discovered this accused on the life of this accused himself. We requested the learned investigating judges to call Nick Dunlap, the author of this book, as a witness, either as a witness of fact or as an expert. But the learned investigating judges, when we made this request towards the close of judicial investigation, said that the co-prosecutors may make this respect during trial because the investigating judges were in a process of closing and submitting the indictment at an expeditious pace. We also respectfully sought before your honors to call this witness, Nick Dunlap. Your honors concluded in your wisdom that it would not be appropriate to call this witness, and therefore, in the light of all this, we would most respectfully submit that since this book has been so extensively referred and cross-referred, it would be in the interest of justice that this is before you. And in making this submission, I would make two observations, and then I shall be done with my submission. The first observation is, your honors, that we made requests before learned investigating judges on filing documents that were in the public domain. The learned investigating judges, both of them being very accomplished in their national jurisdictions in the civil law procedures, told the co-prosecutors in their order of the 19th of March 2009, and this concerned a report about the effect of this trial on the lives and mentality of the victims of the Khmer Rouge, said that this is a public document, and if the co-prosecutors or the judicial officers later wish to use any of its findings, they may do so at their wish. Now, we are not citing this as a binding precedent for you, but we would most respectfully submit that this, being a public document available in the public domain, referred extensively during this trial and judicial investigation, read by the accused, subjected to some examination, it should be, and most respectfully ought to be, admitted for your consideration at judgment. Your honors, these would be my preliminary remarks, and if my learned friend has some very fundamental objections to this, or should your honors have certain questions to me, I shall be most respectfully available to answer specific questions. But without further ado, I would rest my case here.
the President, the Defense Council, do you have anything to make observation or any objection to the request made by the co-prosecutors? Mr. President, Your Honors, and the hearings. I would like to raise some observation, and the decision will be in the hand of the trial chamber, and I will respect the judgment of the trial chamber. My observation is on the armed conflicts between the DK regime and the government of Vietnam. So the armed conflict was arisen between the top government between the two countries. So if we include these documents into case 001 to aggravate it against Duch, it seemed to be very serious. It is unacceptable to me, and I frequently remind the chamber that if we include these documents into case 002, it might be more appropriate, because the armed conflict between the DK government and the Vietnam government, it was at the government level, it was not at Duch level. In addition to that, the DK government, there were 4 people, including Pol Pot, Ieng Sary, Von Vet, and Son Sen. 3 of them were deceased, only Ieng Sary. So if we include these into case number 2 and we examine against Ieng Sary, it would be okay. In addition to that, I also mentioned that if we take the armed conflict between the forces of the DK regime and the Republic Socialist of Vietnam to use and to try only the Cambodians, it seems injustice or no justice, because many Cambodians dies, and if you use that to use only against the Cambodian, it's not appropriate. However, we should try to find the light to prove that justice for Cambodian and for the international community. So if you include the document related to the armed conflicts in this trial, so what happened? The acts, the fighting, and they kill the Cambodian prisoner of war in Vietnam. Why we don't have the war crimes tribunal? And the Vietnamese prisoner of war fight in Cambodia, and they end up in Cambodia, and we tried them in this, the responsible person for that. So to me, I think that we should include this document into case 002, it would be more appropriate. So, however, it is in the hands of the trial chamber. This is just my observation.
Maître Roux, vous souhaitez intervenir, je vous en prie.
Well, Mr. President, ladies and gentlemen, I would like to make a few additional comments. After the long presentation of my colleague from the prosecutor's office, I'm perfectly willing to be magnanimous but I don't want to be stupid. With regard to the armed conflict, which Council Kasavut mentioned, for 6 months, I've been saying to the Office of the Prosecutor, if you wish to file over 200 press articles which exist only in English, that is your responsibility. But what we ask you to do is to produce at least a one-page summary giving us the gist of what the articles you want to submit contain. Because if at some point I were to discover that you have produced documents which had to do with something else, then I want to be able to make you accountable for it. And now, for 6 months, I've been waiting for a single-page summary. And then I'm handed a document which is several pages long, but that's not what I asked. I asked a one-page summary explaining to us this is what can be found in the 200 press clippings that you feel are required in order to demonstrate armed conflict, about which Council Kassavi says, well, first and foremost, it has to be discussed in case number 2. So I'm still waiting for that one-page summary which you had committed to produce. And I would like to add, Mr. President, distinguished members of the court, that with regard to this conflict, the discussions we've had with the Office of the Prosecutor were dealing exclusively with press articles. I had personally expressed the opinion that I thought that 200 press articles might be exaggerated. But what have I discovered? I have discovered that under cover of this purported agreement of mine, there appear to be 5 books, analytical reports, military reports, telegrams, video clips. I have never approved any of that. Never. So, magnanimous, yes, you will find that in me. When I say, if you wish to submit 200 articles, I believe it's too much, but that is your responsibility. You should take responsibility for it and give us a one-page summary of it. Full stop. Don't take advantage of that to pretend that you have my agreement to slip in a slew of documents about which I have never given any form of agreement. Coming now to the map you suggest, we have no observation. That was your first point. On point 3, testimony and documents commented on by the accused. You are returning to an appendix or annex A to your new request, because you're never short of submitting motion after motion after motion and application. I tell you that your request of 19 August 2009, which is 15 pages long, has yet to be translated into French. I don't know if there's a Khmer version. These are not acceptable working conditions. So what I understand from the request or application of 19 August is that the Office of the Co-Prosecutors wishes that there be entered into the file all of the reports of interrogation by the co-investigating judges. Obviously, the defense has no objection to submitting to the chambers or putting before the trial chamber the reports of the interrogations performed by the investigating judges. But you always want more. And so the Office of the Prosecutor then takes the liberty of singling out document 25 with reference D90, 25 June 2008. And I would like to respectfully call the attention of the Chamber to the fact that this report of interrogation belongs to case file 2. It should therefore not be entered into case file 1. Thus, all of the reports or transcripts of interrogations made by the investigating judges in the framework of case number 1, yes, without exception or exclusion. All of the documents that were commented upon by the accused at the request of investigating judges, whether they are appended to these transcripts or handed in later by the accused, yes, of course, that was part of the work of the co-investigating judges, and in order to save time, on several occasions, co-investigating judges gave documents to the accused in the presence of co-prosecutors and asked the accused to make his comments. All of this is in the investigation file, and obviously, since all of this has been argued in a contradictory fashion, the defense is certainly in agreement with placing these in the file. However, in your list, dear colleagues, co-prosecutors, you forget that there were 2 reenactment minutes. I know that you've mentioned this very little, and this is a legal act which I continue to consider to be a major one. However, Mr. President, distinguished members of the Chamber, I would beg you to be very careful and make sure that there not be one reenactment report, as has been requested by the prosecutors, but the 2, in other words, Kaing Guek and S21, should be filed. Similarly, we request that your file contain the film of this reenactment, excerpts of which were shown in court this morning by the defense. As for Annex B, which contains 69 witness statements compiled in the course of the investigation, the defense has no objections. However, with regard to Annex 2, mention is made of 60 documents from S21 which are alleged to be, and I say this pointedly, to have been annotated by the accused with accompanying translations. I respectfully beg the court to take note of the fact that the defense voices its firm opposition to submission before the chambers of documents from S21 which were not the subject of debate during hearings. Why is that? Because in the course of the investigation, but also during the debates before the chamber, you will recall that together we realized that there were numerous translation errors pertaining to these documents from S21. In fact, I recall that during the investigating stage, there was a moment when the Office of the Co-Prosecutors was proud, to use a term that was used at length by the Office of the Co-Prosecutors this morning, was proud to present to Duch a document issuing from S21 where it appeared that his signature had been placed, whereas, as it turned out, upon examination, the sign that they were showing simply meant that they came to the end of a paragraph and that this was a sign that was repeated throughout the document. So I believe only in one thing, and that is adversarial debate. And nobody can deny that Duch cooperated with the co-investigating judges and the chamber in the work of deciphering the S21 documents that were shown to him. And it is thanks to Duch and his willingness to cooperate that we were in a position to analyze the documents that were put to him. But it is also thanks to this contradictory scrutiny that we were successful in singling out serious mistakes in the interpretation of some of these documents. Thus, I wish to say to our colleagues from the Office of the Co-Prosecutor, you have had available 1 year of investigation, practically 1 year of trial. On top of that, you have chosen to bring to the bar witnesses who sometimes were of no interest at all. That is your choice. Rather than do this, you should have put in the contradictory debate those very documents. You did not do it, and you cannot today seek leave to put them before the trial chamber with no contradictory scrutiny. Finally, with regard to the book of Nick Dunlop, I recall that Duch has emitted a series of reservations toward this book, at least some of the passages in the book. However, this being said, we will comply with the wisdom of the chamber on that question. So these were the observations of the defense, and the defense itself will later seek from you leave to introduce a few new documents rather than hundreds of new documents. Once again, I regret that the Office of the Co-Prosecutors deems it useful in a trial where the accused recognizes everything he's accused of, deems it useful to bury us under scores, hundreds of pieces of evidence, which for each one of them require translation into all languages and cost time and money for this tribunal.
The President, please, the floor is yours, Mr. Co-Prosecutor.
Thank you very much, my learned national and international defense colleagues, on your observations. Beginning at the very beginning, let me respond to my learned friend Maître Savout's observations regarding armed conflict. That certain accused in case file 2 should be burdened with this documentation and not this, because Pol Pot and others higher up in the hierarchy were responsible for this and not this accused. Your Honors, there's some wisdom in that submission. But the problem for the co-prosecutors in their objective and onus to prove the case beyond reasonable doubt is the charge that the learned investigating judges gave to us under the Geneva Conventions. Now, this accused stands charged for various crimes that have been described in the indictment as confirmed by 5 judges of the pre-trial chamber for being charged with grave breaches of the Geneva Conventions. Now, my learned friend very well knows that to prove grave breaches of Geneva Conventions, one has to prove, as the co-prosecutor has to, the existence of an international armed conflict and the connection that's required between the crimes of this accused with that armed conflict. Without such a connection and without the proof of an international armed conflict, the charge of Geneva Conventions shall fail. Now, I don't want to go into the history of this case that's come before you in the form of the indictment. Before the investigating magistrates, and even before you in this trial, we submitted that this accused should also be charged with national crimes under the 1956 Penal Code of Cambodia. My learned friends vehemently opposed that. If this accused was charged with national crimes, which he indeed stands charged, only national crimes, this connection with armed conflict would not have been required at all. Now, my learned friend cannot oppose national crimes which don't require armed conflict and then say that we should not be able to prove armed conflict, which is required for the charges currently labeled against this accused. So we are bound by the requirements of international law to prove an international armed conflict. Your Honors, I'll not burden you with too much of legal or jurisprudential arguments, but I'll just read you a most seminal description of an international armed conflict, but by one of the best judgments written under international law, at least in its earlier years. This was written by the appeals chamber of the International Criminal Tribunal for the former Yugoslavia in the famous Duch decision. The appeals chamber, comprising of 5 learned judges, held
Defense counsel, you may proceed.
Mr. Roux.
Excusez-moi, mon confrère, de vous interrompre, mais
I'm sorry to interrupt my learned friend, but I do not think this is the time to make your pleadings, your closing submissions and this is not the time to justify your claim for war crimes. What we are not doing a class on war crimes here. If we want to conclude this evening, I do not think we ought to do what you are doing now.
Your Honors, I am not in the business of teaching great doctors of international law like my learned friend is. I was essentially bringing to your attention the requirements of a number of documents to prove armed conflict. And that's why I was reading to you the definition of armed conflict, which I shall not read in deference to my learned friend's suggestion. I should only state that the Duch decision stated that it has to be a protracted violence between states. Now, clearly, to prove a protracted violence between states over a period of 3 years, 8 months, and 20 days, as we are faced in this court, we would be required to bring such evidence that establishes a continuum of conflict, skirmishes of various types, such that it forms a complete armed conflict throughout the temporal jurisdiction of this court. Therefore, these articles are not repetitive, but they are necessarily required to prove this existence of armed conflict and its protracted nature between states such as Cambodia and Vietnam. So therefore, my respectful submission is that it is not repetitive. It is indeed required. Your Honors wouldn't be willing, like any other judges of any international tribunal, to conclude the existence of armed conflict on the basis of one document, or much less admission of an accused. It will not be countenanced by any judge that an admission of one accused would lead to an unquestionable acceptance of the existence of armed conflict throughout that temporal jurisdiction of this court. And I shall not go further. Regarding a summary, Your Honors, our document of 29th of April 2009 was indeed a one full-page summary of what was contained in these binders. They may look big, but they are indeed a collection of documents that are completely and in detail described in our filing E61 of the 29th of April 2009. However, should my learned friend wish, and the Office of the Co-Prosecutor on its own will provide another summary to my learned friend so as to satisfy his suggestion, and we can discuss that with his office. Your Honors, it was not our desire to omit one report of reenactment, and the co-prosecutors respectfully state before you that Your Honors should also admit the second reenactment, and indeed all such documents associated with the reenactments and reconstructions that were undertaken by the learned co-investigating judges. Regarding Nick Dunlop's book, Your Honors, we are not submitting that Your Honors should rely your judgment on the book of Nick Dunlop. We are bringing it before you, putting it before you for consideration. It may or may not be true, depending on what Your Honors conclude on the basis of other corroborating evidence and the testimony of this accused. And therefore, Your Honors should treat that with the scrutiny, with the strict scrutiny that Your Honours will have to apply to all the documents that are before you in this trial to reach a conclusion. Your Honours, the last point, and which became a bit contentious in the response of my learned friend, is in respect of annotations of this accused on the documents produced at S21. While the easier thing for the office of the co-prosecutors would be to go back to its list and filter out such documents, and there were quite a few of them, that have been put to this accused or other witnesses during either the judicial investigation or this trial. Once again, in submitting that Your Honours consider these documents, we were not submitting that all of them may or may not have been authentic, or at least authentic in the eyes of this accused. I would respectfully submit, in respect of Annex D, that I would go back to my chambers, make another list, and confer with my learned friend, and come out with a mutually acceptable list in respect of Annex D. And this should be done in reciprocation for the generosity that my learned friend has just demonstrated in respect of acceptance of other documents. We still maintain, though, that these documents are very crucial, contemporaneous, directly relevant, best evidence that this court has before it. After all, trials of this nature, like you are trying, just like Nuremberg, turn on evidence, because no one witness, no one accused can give you a complete picture of what happened at S21 and the nature and extent of the role of this accused during those 3 years, 8 months, and 20 days. So Your Honours will clearly have to rely, equally if not more, on documentary evidence. But in respect of this Annex D, Your Honours may grant us a week or less than that to go back, confer with my learned friend, and come back with a solution, not before the court, but to file it before you. And then Your Honours, in writing, may choose to decide in the way Your Honours wish to. I hope I have answered all my learned friend's observations. Should Your Honours have further questions, I shall be willing to respond.
The President, Judge Lavenge, you take the floor.
Oui, merci, Monsieur le Président. Je souhaiterais éventuellement
Judge
poser
Lavenge.
quelques questions aux
Thank you,
parties
Mr.
pour essayer de
President.
clarifier le
I
débat.
might wish to put a number of questions to the parties to shed light on some issues.
De documents.
So we have 4 series of documents.
De la carte qui constitue la première série.
The first series is the
un
map.
accord.
I understand that there is a clear agreement between the parties to put this document, this map, before the court. I take it.
Série de documents qui concerne,
There is a second batch of documents.
selon ce qui a été présenté par les coprocureurs,
According to the
l'existence d'un conflit
co-prosecutors,
armé
the existence of an international armed conflict.
de la part de la défense et qu'il y a une objection tout d'abord de
What I
principe,
understand is that there is an objection on the part of the defense in
pas
principle
nécessairement pertinent pour le
to the
dossier
effect that these documents are not necessarily relevant to case number 1
cas des dirigeants du Cambodge
because they allegedly concern the leaders of democratic Kampuchea. The defense further contends that there has not been
prisonniers de guerre cambodgiens qui ont été
an
clonés.
international
J'ai bien
court
compris.
to try
Donc c'est sur la
war
pertinence.
people for
Il y a
the
une
war
objection.
criminals or the prisoners of war who were killed in Vietnam.
Préciser, si j'ai bien entendu également,
I'd also like to
on remet
understand
également à la sagesse de la Chambre.
whether the defense is relying on the chamber for a determination of this matter.
J'ai entendu également donc des objections.
I also heard objections
Il y a une demande qui concernerait environ
regarding
200
an application
presse.
pertaining to 200 press articles or thereabouts. If I understand correctly, the objection is that these press articles are not summarized properly.
Pas suffisamment identifiés.
In any event, they are not identified or summarized. So there are two possibilities
devant la Chambre,
for putting documents before the court, either notification or summary. So what the defense is saying
clairement résumé.
is that they are not adequately summarized. Please let me continue and finish the list, and you may have the floor after
Et
that.
par ailleurs, si j'ai bien entendu, il y a
Further,
une opposition
if I understand it correctly, there is an objection to placing before the court, in addition to the articles, documents that are allegedly books, military reports, or video footage.
À ce stade, je n'ai pas entendu
At this
d'objection
stage, I have not heard any
que
objections
ces documents ne seraient
to the
disponibles
fact
que dans une
that
seule langue de
these
travail
documents
de
are available in only one of the working languages of the court. I wish to have confirmation on this point so that there will be no difficulties subsequently.
S'agissant par ailleurs donc des procès-verbaux d'interrogatoire
Concerning
ou
interview
des
reports
procès-verbaux de reconstitution,
or
je
reenactment
pense
reports,
avoir compris
I
qu'il y
believe
avait
I
en fait
understood
un accord
that there is
en tous les cas des
an
co-procureurs
agreement
de
between the
défense
parties, or at least the co-prosecutor and the
soient
defense,
effectivement
to the effect
considérés
that
comme étant
these
versés
documents
au
should be
départ.
considered as having been put before the chamber.
Il en est de même donc
The
des
same
déclarations
applies
de témoins recueillies
to
pendant
witness statements that were collected during the investigation phase.
S'agissant de l'annexe D,
With regard to Annex D,
60 documents
that is 60
présenteraient des
documents
annotations de la main de
which
l'accusé,
are annotations made in Duch's hand.
que un certain nombre de ces documents
It seems to me that some of these documents have already been put before the court.
si les co-procureurs
I do not know, therefore, whether the co-prosecutors have prepared a list of these documents already put before the trial chamber,
60 documents qui sont entièrement nouveaux, qui n'ont
or
jamais
whether
été
these are 60 completely new documents that have never been put before the court.
Enfin,
They will not
s'agissant
be
du
treated in
livre
the same manner.
Dunlop, là aussi,
Lastly, there
je
is
souhaiterais que
the
les
book
choses soient
by
claires de la part de la
Nick
défense,
Dunlop.
qu'elle dise
I would like the defense
que ce
to
livre est
state
disponible
clearly
dans une version anglaise,
whether
le fait que ce livre soit disponible
this book is in English, and the fact that this book is in English
par une quelconque objection.
raises whether the defense is objecting to the presence of this book or the existence of this book only in English.
Your Honor, sorry to interrupt. Just to clarify that it's also available in Khmer. I'm sorry, I didn't mean to interrupt, Your Honor.
Alors, merci, Monsieur le juge.
Mr. Ho, thank you, Your Honor.
En ce qui concerne les documents à l'appui du conflit armé,
With regard to documents supporting
défense
the
vient
case
s'appuyer
of the existence of an armed conflict,
dans la reconnaissance des faits
the defense wants to reiterate its position, which is set out in the
reconnu qu'il y avait
facts admitted, where the accused admits that they were war prisoners of war from the 31st of December 1977. It is an admitted fact.
Malgré ça, les
In spite of that, the co-prosecutors considered that it was necessary
porter le débat devant votre chambre
to make submissions in this regard before the court, asking the court to decide, to determine that this armed conflict spread all over the country during the DK era. From the outset, the defense has always said that this was not one of the points of case number one. The defense has said this before, from the start. And then the prosecutor asks the defense whether the defense agreed to putting about 200 articles before the court. Actually, it's more. It's 138 plus 87. I think Duch is better at mathematics than I am, and he could give you a general figure, but I can tell you that it's more than 200 press articles only in English. So I told my learned friends on the other side, if you want to put these documents before the court only in English, I would like you to be responsible for preparing a one-page summary of what these articles are about. It does not seem terribly difficult. A summary in French. And in reply, I have dozens of pages in English with summaries of each article. And this is how you flood a tribunal and translation services with documents. I maintain that these documents are totally redundant. There is no need to flood the chamber with 200 useless press cuttings. I'm not requesting a translation into French because I do not want to submerge translation services. I just want a summary, a one-page summary in French, in which you will tell me what the articles contain. Is this perfectly clear? I asked for this 6 months ago. With regard to your other question, Your Honor, that is whether they could identify, whether the co-prosecutors can identify S21 documents which have been put before this chamber. This is a matter for the prosecution, because it is the prosecutor that put before the court documents on screen, and it should be easy for them to make a list of documents that were put before the court and subjected to an inter partes debate. So these documents and other documents submitted to the co-investigating judges and which were the subject of an adversarial debate, we will not object to. Lastly, regarding Mr. Nick Dunlop's book, I am going to be magnanimous, as my colleague says. The book exists in Khmer, although it doesn't exist in French, so it is in at least 2 of the tribunal's languages. I consider that it is useless at this point to overwhelm the translation services, although I would have been pleased to have a French copy to read. So at this stage of the proceedings, we are not going to ask for another translation because there is a Khmer version that Mr. Karsabut has been able to read. I hope I have covered the questions that you put.
The President, I notice the Defense Counsel is on his feet. You may proceed.
Mr. Hu, I beg your pardon, Mr. President, but at this stage, whilst we are discussing the documents that will be put before the trial chamber, It is my view that we should add the psychological assessment report. I think it would be useful for the court to order that all documents that will be considered as having been put before the court should be placed on the tribunal's website. This is a public trial. It is indispensable that anyone who so wishes may have access to documents if these were discussed publicly or if they were considered as having been debated publicly. This is a fundamental principle, that is the public nature of proceedings.
The President, the Chamber would like now to give the floor to the civil party lawyers. If they wish to submit any additional documents, and you have to clearly state whether your submission is related to the existing and remaining documents with proper identification, so that the Chamber can follow the procedures and that the party should adhere to the instructions given by the Chamber. And if they have new additional documents, they should state so as new documents. And that would help the Chamber for its examination and consideration before it decides on its admission. So, Civil Party Lawyer Group 1, you take the floor. T. Good afternoon, Mr. President, Your Honors, distinguished members of the court. My name is T. Srina. I'm representing Civil Party Group 1. And my colleague is Alang Wagner. This is the day, the last day of the hearing. And I would therefore like to make two requests. Both requests are related to submission of documents for examination and decision. My first request is related to documents already existed in the case file. And my second request is related to submission of new evidentiary documents which are not yet part of the case file. And for my first request, that is the documents already in the case file, they are related to the confession of Main San, alias Ya, with the ERN from 0009497 to 0009682. Between those pages, there are some relevant parts, especially on the page with the 0000 94 99 and 00 00 9500, where there was an annotation of the accused and the page with the EIN number 00 00 95 74, which shows the letter the accused wrote to Man San alias Ya. In the last paragraph of the letter, and the page with the EIN 00 00 9587, it is at the point where the accused wrote a letter to Comrade Pon. It's the third point of the letter. And the EIN in English and in French, I apologize as I do not have those EIN numbers. However, these documents have already been translated and have been placed in the case file already. And I seek leave from the chamber to admit this document into the case file as basis for your Honor's judgment. Regarding my second request, it is related to new documents which are not yet placed in the case file. We submit that we would like to make an oral submission of these new documents related to this S21. The reason for our oral submission is that we already made our written submission and we sent our submission to the translation pool, but unfortunately the translation unit is too occupied with various other urgent requests, and they are not able to produce the translation for us on time. Therefore, I would submit the written request with its translation in due course. I believe the translation shall be done before the final oral submission. The evidentiary documents that we wish to submit are delivered to the Defense Counsel for their own examination and decision this morning. In relation to those documents, we submit to include 18-page document. They are daily list of prisoner at S21. In these documents, there are annotations of Ho. I apologize. There is a signature of Ho, who was a member of S21. And the signature indicates that the list were made by Ho. in order for his report to be sent to the upper echelon for their examination on the daily activities of the prisoner at S21. On this list, there are tables indicating the daily number of prisoners and the newcomer prisoners, as well as the prisoners who died at S21, as well as those prisoners who were sentenced to be smashed. I believe these lists are new and crucial evidence that ought to be included in this 001 case, because this list show the situation of the prisoners at S21, and no such list exists in the case file so far, indicating such situation at S21. In addition, this list also indicates clearly the fact that the detainees at S21 who died by various means, which are in addition to those who were sentenced to be smashed at Trường 8. Amongst those lists, there are also indications of smashing by blood drawing, and that a prisoner at S21 committed suicide by hanging himself in an individual cell or in a cell at S21. This list also indicates the tortures inflicted upon the prisoners who died later on, and some of prisoners also died due to various diseases. And the list also indicates that prisoners died during torture during the interrogation process. My group also examined the list and compared the list against the list already exists in the case file, which is E68.1, and it is a list of prisoners to be smashed after they had been re-educated. And the list had been placed before this chamber for confrontation already. We compared the number and the names of the prisoners who died at S21 against the list that we newly found. Then we found out that in our new documents of the list of the daily activities of the prisoners are not included in the list of prisoners to be smashed at S21. And this is the reason of its difference, and this is a new document supplementing the existing document already in the case file. Therefore, Your Honor, I believe the 18 list that we newly found shall be included in the case file for the interest of the chamber to ascertaining the truth, as well as to seeking justice for those who died at S21. Therefore, I urge journalists to grant the admission of this list as part of the case file. Thank you.
The President, please, Mr. Alangwena, the floor is yours.
Bonjour, Monsieur le Président, Madame, Messieurs les juges. Très brièvement, pour complémenter.
Oh, Mr. President, distinguished members of the court, briefly to add to what my colleague said. Perhaps, well, I'd simply like to be sure that everything is clear on 2 points. First of all, to be correct with the interpretation service. As you know, the civil parties were quite busy these last few days because following your order, we must submit a motion on reparations tomorrow. So there was a great deal of discussion among civil parties, and we were only able to submit the motion today to the translation department, which Gislena has mentioned earlier, and that is the reason why we handed it to our colleagues from the defense as early as we could, and that was 2 hours ago. And we expect that this document will have been translated by next week, since Friday and next Monday are holidays. And that is why we took the liberty of submitting a motion orally, which will give our colleagues time to reply and to have a maximum of time to work on this and to intervene before your chamber. Now, an additional element with regard to the relevance of this motion, the fact that it is important for our civil parties. And the reason is the following. As Tishrina told you, what we have discovered, first of all, it's 18 one-page lists. These are daily lists. These are 18 one-page lists. And if there was really a list being made every day, there should probably be a great deal more of them. But we're talking about 18 lists today. What seems to us important is that in these lists we have 18 names of persons who were detained in S21. In our motion, there will be a statement by Toslen attesting to the fact that these lists were found in S21. These 18 lists are persons who were not executed but who died either under torture or because of the conditions of detention and by suicide in one case. Of these 18 names, we compared these 18 names, as Tishrina said, with the consolidated list of the co-prosecutors. And for 14 of the 18 cases, these names are not to be found there. In other words, these daily lists are mentioning persons who died but were not executed, and their names cannot be found in the consolidated list. That's important for us. And why is that? Because, as you know, for 4 of our clients, and I have spoken at length about this, we were unable to supply additional evidence, and since the accused and as the accused and one of his lawyers have quite rightly submitted, the names of the relatives of our clients are not found in the consolidated list. Therefore, if we could submit these lists before the trial chamber, that should make it possible for us to support our argument that it is more than probable probable, as I said, that these persons died in Tuol Sleng, perhaps through other means, not execution, but illness, torture, suicide, or other. And it would be logical that the names of these persons cannot be found in the consolidated list. And again, we think it's important for us to be able to rely on these documents because that will help us buttress our final submission, which is that for 4 of our clients, the fact that the names cannot be found on the consolidated list does not mean that these persons had not been detained in S21. One more word and then I will be done, and to tell you that we were brought into this case in January. We have limited means and a limited team. We've really made all efforts to scrutinize all the documents. This required a great deal of time, and we were as diligent as we could in order to include all these documents in the file. My colleagues spent an enormous number of time in Tuol Sleng manually going through the documents to identify these, as is stated in our writings. I know it's late, but again, we believe that it would be important for the case and for our clients specifically that these documents be put before the trial chamber. Thank you.
The President, the Council for Civil Party Group 1, can you mention the source of your documents and the reason why it is late in submission, and you just make the request just at this moment? Tisrina, thank you, Mr. President. I will take this floor to provide clarification. We found this document at Tuol Sleng Museum, and I spent quite a lot of time to find the documents as mentioned by my colleagues. Then we found this document and we requested for a photocopy, and we need some time to do that, and we need to make a request to the Ministry of Culture who responsible for the museum, and we need to have the permission to make copy of the documents at Tuol Sleng Museum. And we wait some time, 3 days or 1 week to get the permission, because sometimes the person in charge was busy, and we received that on the 26th of August 2009, and we received the document, and we spent some time to read and to discuss with the civil party, and we need some time to spend to look on this document. Another point, our delay in submission of this document is that our group was formed to participate in case 001. We started in mid of January 2009, and it is the time the investigation is closing and the hearing was started. So during this period, it was very stringent for us that we need to look a lot of documents that should be used in this case 001. In addition to that, even though our group had a short time to study the case, but we made our effort to find additional documents and material for using in the hearing so that we can ascertain the truth. We try to look for evidences every day, even though we need to spend some time in the hearing, And in our free time, we need to find more evidence and document to support our case in the hearing. These are the grounds for our late submission of the documents. Thank you, Mr. President. The President, now it is time for the trial chamber to adjourn 18 minutes, and we will come back in session at 3:18. 3:30, correction.
The President, please be seated. The chamber is now back in session. The chamber would like now to give the floor to the defense counsel so that they have the opportunity to put questions to their client. This is in relation to the questioning of the accused character. Defense counsel, you take the floor. Kasabut, thank you, Mr. President. Good morning, Your Honors. Good morning, ladies and gentlemen. Mr. Duch, when you studied at the primary school, did you ever see a photo of Mao Zedong? If you did at the primary school, what was your feeling toward his photo or portrait? The accused. I did not see his portrait at a school. It was at a Chinese house who was a vendor at the stone market. It was actually on a postcard. It was a portrait of him standing. It was a half-body photo from his thigh. Actually, it's from, yes, from his upper knee to the top of the head. At that time, the Chinese people were grateful to Mao Zedong as he was able to resolve the livelihood of the Chinese people in China. And of course, I was rather excited as the relatives of my late grandparents were poor people living in China. Kasabut, thank you for your response. And when you were studying at the Kampong Thom High School, how come you call Susat as uncle and auntie, but for the other person you only refer to as elder? What were your feelings and decisions at the time? Response. The five of us, 3 boys and 2 girls, were in similar age. We studied in a work group and we were leading students in the school. I was afraid that the work group would lead to love affairs. So the 4 of us referred to her as elder sister, and regarding Susat, I refer to her as auntie because I knew her nephew. So the reference to elder sister and aunt were to avoid the sentimental feeling toward love affairs. Thank you, says Kasavut. When you were studying at the pedagogical institute, were you trained to join the revolution, and if so, from whom? Response: I made Son Sen in late '63. I was still in the elementary school at the Teacher Training Institute, and that I should consider that only when I passed the exam. After I passed the exam, my focus was still on the mathematics subject. Only after the arrest of more than 10 people, including Chai Kim Hua, I threw away my mathematics books and I started to join the revolution. My network at that time was with Kong Saron and another student from Kampong Thom. He was from the first group of the students at the time. So my network started from there. And later on, through various stages, I went back to my first network. Question: in 1999, did you ever return to Susat's house? Response: I did not go to Susat's house in 1999. That is my frank response. I went to her house on the 21st. Actually, it was in 1967 or 66. I cannot recall exactly. Actually, it was in '67. I went to say goodbye to her before my departure to join the revolution. It was the 21st October '67. Kasavut, thank you. So in 1967, you went to Susat's house. Did you ever stay there overnight? Response: I went there in the evening and Sat and her husband, Swai Saran, also joined the revolution. At that house, there was no other bed and a mosquito net. So both of them asked me to join them, sleeping together under one mosquito net. And a child was also sleeping there together. So I slept overnight together with that family. Question: when you were sleeping with 3 adults and 1 child, did you discuss on any matters? Response: actually, we stopped talking already. We discussed before we went to sleep. We talked about my farewell to them to join the revolution. And we were so sentimental toward each other. And she was feeling rather sorry to see me go. Question: and before you fled to the forest in 1978, did you go to pay homage to your parents? If so, when you went to pay homage to go to the forest to struggle, and what was the purpose of you running into the forest to struggle? Response: the 21st, I went to Sat's house. Actually, on the 20th, I went to pay homage to my parents. And at night, when my younger siblings slept, I spoke to my parents. My father was pity on me. He gave me the lucky amulet. Although I did not believe in luck, I accepted it from him to make him happy. And as I reported earlier, I joined the revolution, and I wanted my parents to join the revolution as well. So when I left them to join the revolution, I went to say goodbye to my parents in order to join the revolution to liberate the country. That was my feeling at the time. Thank you, says Kasavut. Can you reiterate the period between 1970 to 1975? You were in the liberated zone, and you clearly witnessed that the CPK killed people or started to kill people from that time. Is this correct? Response. I witnessed the killing of people. First, it was at the Sector 25 in Saang Kothom, and later on at the Om Leang, where I was assigned to work to do the police work. Thank you, says Kasavut. Upon witnessing such killings, it was contradicting to your purpose. When you pay homage to your parents to say goodbye in order to join the resistance, is this a fair assumption? Response, that is true. It was contradicting to my concept. Question, upon seeing such events and you knew it was wrong, why did you not flee from the Khmer Rouge group? Response, as I have informed the chamber from the beginning and even during the investigation phase, I had a total conviction that I did not make any single decision to arrest any person. I was only to receive those people who were already arrested, and then I would have their confession and sent to my superior. And the people who were responsible before the history were them. Regarding the smashing of people, I would not be able to do it. At that time, Chai Kum Hu, alias Hong, told me that then I should allow the peasant class to do this work if I was not able to do it myself. So, in short, they were responsible before the history. And secondly, where could I flee? Along the way, there were guard posts. I would be arrested. But if I were to successfully escape, then I would escape to do what? Because I knew that Lunar government would be defeated. And I already informed the chamber that I had some complicated matters with my uncle, who married to a niece of Lunar. And I was still grateful to my auntie and my uncle, but I knew that Lunar government would be defeated, so I should not run toward the defeated people. Thank you, says Kasavut. So can you reiterate the fact that at S21 you dissatisfied with your role as the chair, and you dissatisfied, despite that you still tries to fulfill your duties in order to survive, because at that time you witnessed that Nat, the former chairman of S21, was arrested by the CPK and smashed at S21 as well. So you started to feel scared and were wondering when your turn would be next. And if you were accused as an enemy by Onka, then you would be smashed. Is this a fair assumption? Response, the only exit is survival. And in order to do that was to fulfill the duties assigned to me. As I have repeatedly told the chamber, some people made analysis that I outperformed my role. And I responded that there is no such criterion to measure the performance during the Pol Pot regime. They were interested in notifying, in monitoring these people or that people activity, and that activity would be considered treacherous if it was a little bit wrong. So I tried to survive on a daily basis, and that's what happened. And yes, you can say I am a coward person. Kasabut, thank you. 7 January 1979. At 2 p.m., you left S21 compound, and at that time, you had the ability to escape from the Khmer Rouge group. And as you just stated, a piece that is stuck within a wheel in motion can only be taken out when the wheel stops moving. But 7 January 79 was the day the Khmer Rouge was defeated. That is, the Khmer Rouge mercenaries was halted. Why you did not escape from the Khmer Rouge, and why you still had to follow them? What was your concept or thinking at the time? Response. At that time, my thinking was that it was shown through the testimony of the expert General Ul yesterday. The Vietnamese Communist Party was that if I were to run to them, would they trust me? And that was a major issue. And the second issue is that I had hundreds of followers or subordinates. And if I were to flee, what would be happen to my subordinates? Would they be arrested and detained? These were the true matters that forbid me from escaping.
Council, thank you. So far, you have already asked for forgiveness and expressed your apologies to the victims and asked them to forgive you for all the misdeeds you have committed at S21. But the families of the victims have indicated that these kind of apologies are not genuine, are not from your genuine heart. So can you please tell the court whether those apologies are really genuine? Response. CPK has educated its members that anyone who were arrested and sent to S21 must be regarded as enemies and smashed because they were people who were opposing the party. When I said I would like to express my apologies to the victims, the family of the victims, even to my staff members, at that time, I did not regard those people who perished were the criminals or those who committed wrongdoing. It is the CPK, my CPK, which is the criminal. I therefore submit that the misdeeds that I have committed toward my people have to be responsible by me, myself, because I realize that I have committed those wrongdoings and there is nothing else to compensate for such misdeeds other than seeking apology, expressing apologies. And without having expressed this, the other people who might have committed crimes may believe that they have done something wrong, the correct thing. So I would like the Cambodian people to judge my apologies, because I treated the people who died as those who have done nothing wrong, who were innocent, and that the decision by the court toward the genuinity of my apologies is another matter. Counsel, thank you. If I'm not mistaken, yesterday or the day before, the National Court Prosecutor indicated that your apologies or the admittance of guilt is only 50%, and that the 50% of such a thing is still hidden. So can you tell the court whether 100% of such apology admission for guilt have already been expressed? Response. The investigating judges, the co-investigating judges asked me a lot of questions, and I have, to the best of my honesty, responded to them. And during the court proceedings in this chamber, the judges of the chamber, of the bench, the prosecutors, the lawyers for the civil parties, have put several other questions to me, and I have already responded honestly to them. And what I have already completely responded to the co-investigating judges, I would have said so. And if I found out new thing that I needed to reveal to the court, then I had to do so, and I did not intend to hide anything. The crimes that I have committed have to be responsible by me myself, and as I mentioned time and again, that a dead elephant cannot be covered by a rice basket. And that I also even quoted another slogan that the crimes, the huge crime committed could not be covered by 2 leaves of tamarind. So I think this is all I needed to tell the court, and it is really true. Counsel, thank you. When Pol Pot still alive, Pol Pot declared that he did not really acknowledge the existence of S-21. So how did you feel back then? Response. It is the secondary matter. The first and primary matter, it was in China, in Beijing, because Yon Yat, the wife of Son Sen, said that the experts from Sweden came to inspect the remains of the dead body, and they believed that those bones were those people who died after the 7th of January. So I already indicate that it was the moment that history was misleading by stating so. Later on, Nate Thayer told me that Pol Pot rejected that when he was in power, there was no S-21. Only when he got to the Thai border, then he noted that in the media, in the Thai media, there was the existence of S-21, and that he stated, Pol Pot stated that S-21 was orchestrated by the Vietnamese, and I could not really accept it because it is the history. I know the history, and I could not really accept it. And I admitted that I was the chairman of S21. How come you said that S21 was created by the Vietnamese? Counsel, thank you. The last but not least question. Could you please indicate to the court, after you have been familiar with the new page of history and having admitted your guilt, and after having seen noted that the people who died were executed arbitrarily and they were innocent. So can you please tell the court about your state of mind in regard to this matter? Response. As I already stated, I joined the revolution to liberate my people, to pay my, to be grateful to my parents and my nation. But by the end, the country was falling into the complete tragedy, and more than 1.7 million lives have been perished. The economy in the whole country collapsed, culture has fallen down, and these make me find it difficult to point the finger to anyone. And as a man who believes in justice, and I acknowledge that it is the achievement of the CPK in which I was the member. That's why I said that all crimes committed in Cambodia have to be emotionally and psychologically responsible by me, and the Cambodian people can actually point their fingers straight to my face and they can reprimand me for whatever they would wish to say, and I will be solely and personally responsible for the crimes committed, both legally and emotionally. I would like to apologize. I would like to seek the forgiveness from the victims, the family of the victims. And this is my conviction and commitment before our nation, and that I have already been fallen into the misconduct. Last, I already asked the psychologist and how I should do to make sure that Cambodian people really want to put me back into the society and recognize me again. Counsel, thank you. With Mr. President's leave, I would like to share the floor with my international co-counsel. The President, Mr. Francois Roux, you may now proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Well, Duch, we are coming to the end of this trial, to the end of your statements. Your lawyers, as you have understood, wish to give you the opportunity of giving final explanations. You know, and you've understood this through the questions of the co-prosecutors, there are still certain doubts that remain with regard to your admission of guilt in spite of all your statements. And some continue to doubt the fact that your remorse is sincere. So 3 or 4 questions still, no more, because you've already spoken a great deal. Concerning admission, I believe that I can suggest to you that we reread together what the prosecutor is expecting from you. And then I will ask you to give a single reply, a yes or a no. You are aware of the fact that in the Bible, the book which you love, it is stated that your yes must be a yes and your no must be a no. So, Duch, in the preliminary statement of the co-prosecutors on 31 March 2009, page 69 of the French version, line 22, the international prosecutor, Mr. Robert Petit, said the following. Therefore, if at the end of this trial we must establish the truth about what has happened in S21, I would respectfully contend that you will need to confront the accused with the facts of the case and the sole logical conclusion that may be drawn from this. Rather than an image of someone acting against his will, which is the image that he tried to give throughout the investigation, nearly unaware of the atrocities that were being committed around him by his subordinates while he was busy in his office, concerned with taking notes. He was, said Prosecutor Robert Petit, he was in effect and in reality the person who enjoyed the trust of his superiors and thus implemented with devotion and mercilessly the persecution by the CPK of the Cambodian people in S21. Should he admit that, then and then only can the accused genuinely claim to have confessed to his crimes and thus benefit from the consequences of these admissions. Duch, we have come to the end of these debates, and with regard to this, I have only one question to put to you. Do you admit that in reality you were the man who, enjoying the trust of his superiors, implemented in a devoted and merciless fashion the persecution by the CPK of the Cambodian people in S21? Do you admit this, yes or no?
Response. Yes, I completely admit.
Je l'admets totalement.
Messieurs les co-procureurs, arrivant à la fin de ces débats,
prosecutors, as we come to the end of these proceedings, I have no doubt that you will be able to draw all the consequences from this admission of guilt. Duch. Yesterday, during the statement of His Excellency Stefan Hessel, the question of Albert Speer was raised. He was one of the people who stood trial in Nuremberg. Just as you have just done, Albert Speer also admitted before his judges his responsibility. Following that, one of the prosecutors, Mr. Henry King, who had accepted to testify in your trial, Henry King visited Albert Speer on several occasions in his prison. They spoke a great deal. They met again after Albert Speer was released, and Professor Henry King wrote a remarkable volume which he wanted to share with this chamber. So I have one question. Duch, if Mr. Smith or Mrs. Chileng wish to meet with you in your prison, would you be willing to speak to them?
Response. Should anyone from the prosecution wish to meet me, I would then be very grateful and welcome their visit, and I will be telling them whatever they would like me to tell.
Let us now come to the question of the sincerity of the remorse you have expressed. The investigating judges in their closing order, which I've read several times over, have stated that you did indeed express remorse to the victims throughout the investigation phase, they stated also that you cooperated throughout the investigation, and that, amongst other things, you accepted to take part in the reenactments in Chang Ek and in S21. Your lawyers, we came to see you and we asked you the question, would you be willing to return to Chang Ek and S21? And you told us, yes, I am ready. So then, your lawyers contacted the investigating judges and told the investigating judges, if you wish to undertake a reenactment, the accused is willing. And they did organize this reenactment. The first time in the history of international criminal justice that an accused was returned to the venue where his crimes were committed. The first time that you yourself returned, no longer as the chairman, but between two prison guards, between two prosecutors. That is how you returned to Chang Ek and to S21. My question, Duch, and I speak to the man here, what did you feel when on that February morning in 2008 you returned to Chang Ek? Please tell us what you felt in your heart at that time when you arrived, when we all arrived at Chang Ek. Tell us about yourself, about what you felt, please.
Response. Chang Ek, when I was the chairman of S21, I tried my best not to pay a visit to the location. But it was inevitable because I had to go there once. It was not at that time did I go there to show that I was the powerful person in the eyes of those who already died. But my superior already made such request that I wouldn't dare, that I go there 3 times. But then I could only, the request was made 3 times, but I could only go there once. The second time when I went to the vicinity along with the co-investigating judges, I have not realized until today that it was I who was the first criminal who had to pay a visit to the locations of his crimes.
J'étais le criminel principal qui se rendait sur les lieux de ces crimes.
When I made the decision to go there, I had recalled the dead souls of the more than 10 or 12,000 people who died.
De plus de 10 000 personnes qui ont trouvé la mort en ces lieux.
I had been thinking of the children who were executed and who were executed in a very harsh manner when they were smashed against the trunks of the tree. And I had been determined that I had to go to the location. In order to kneel down, to pay homage, to seek the forgiveness and express the apologies to those dead souls. And also I was there to dedicate for the people who died as a Christian. I had to do that. So this is the feeling and that was expressed in relation to my visit to that location, and this feeling is well shared, like the moment I am here also. That's all.
Mr. President, with regard to the next question, I would like an excerpt of the video of that reenactment be shown on screen, and so we have asked the AV unit to please display an excerpt of evidence D48/2, Annex 2, which is the end of the reenactment. Perhaps we could start the tape.
Pour être précis, à la fin de la
to be specific, at the end of the reenactment in S21, Duch requested that he be allowed to read a statement on the spot for the victims in the presence of all the participants. And so I would like that this excerpt be played in the hearing room at present.
The President, I noticed the International Court Prosecutor on his feet. You may proceed.
Your Honour, I'm not quite sure what the purpose of playing the video is. I think we've seen it before, and I also think it's the type of showing of evidence that would normally be put forward in a closing address. So I just wonder what the purpose of showing this evidence is, and whether in fact it's actually got a question related to it.
Mr. Hu, Mr. Prosecutor, I know that my learned colleague was not present during all the hearings, and perhaps he might not have been aware that the passage that we are trying to show now is not one we have seen before. I fail to see how you can forbid me from putting a piece of evidence on the record of the case before the court. Mr. President, what I'm asking is to put a piece of evidence before the court. It is a video recording of the reenactment. I do not think that this is any matter for the prosecution at all.
The President, the Chamber allows the showing of the video clip as requested by the Defense Counsel. Court officer, can you arrange to have that video clip, D48/2, to have it shown on the main screen of the courtroom, please?
Mr. Hu, for purposes of clarification, I'd like to recall that when we showed an excerpt of the reenactment before, this came from the beginning of the record of the reenactment in S21, where the accused asked to read a text. But he stopped because he broke down and wept. So we are now at the end of the reenactment, not the beginning. That is when the accused was able to read his prepared statement. This is what I wish to show to the chamber.
President, the AV unit, you know that the only end part of the D48/2 shall be projected on the screen.
Messieurs les co-juges d'action, Monsieur, Madame le procureur.
Your Honors, I was frozen with great terror when I stepped into those premises where a dreadful and terrible calamity had occurred to my country, my people, and myself. For one thing, I have flashbacks of unfortunate victims and their families who had been subjected to hardship, torture, disgrace, and countless inhumane acts before they were put to death. I am filled with indescribable remorse. Therefore, I agree to submit to trial in the framework of S21 alone. And I have made a strong commitment that I will do whatever I can in order for my country, people, victims, and their families to obtain justice. Similarly, I feel great pity for the personnel of S21 who were forced to perform their task together with me against their parents and their own wills. Among those personnel, some had been forced to be in danger there. This catastrophe awakens my memories, and I am very sympathetic towards myself that I had been trapped by their ideology and had accepted all the assigned tasks. Which were criminal in nature. My acts formed part of a mechanism which resulted in a chronic disaster for my country, my people, and me. Whenever I recalled those incidents, I hold a grudge against the leading apparatus which found every means to navigate this movement towards a great tragedy. And I also get mad at myself, who submitted to their ideology by adhering to their criminal regulations without clear consideration. My acts, therefore, have shown that as the president of S21, I have undeniably participated in committing crimes against humanity on the whole S21.
immanquablement qu'en tant que chef de S21, j'avais participé aux crimes contre l'humanité dans le cadre de S21 tout entier.
Your
Je
Honors,
tiens à vous remercier, Monsieur les co-juges d'instruction. Monsieur, Mesdames, les
Mr. and Madam Prosecutors, I would like to express my sincere thanks that I have been taken here. Please allow me, Your Honors,
je vous demande
to offer my apology to all victims
pour toutes les misères.
De toute façon, la déclaration sera versée au procès-verbal.
បើចឹងបើចឹងបញ្ចប់ប៉ុណ្ណឹងហើយបើសិនជានេះគឺឯកសារហ្នឹងអាចបញ្ចូលនៅក្នុងសំណុំរឿងហើយភាគីទាំងអស់អាចមើលបាន
Please allow me to offer my apology to all victims who were subjected to very severe hardship at that place until the time when they were put to death or until 7 January 1979.
Qu'elles ont subi ici depuis le jour de leur arrivée jusqu'au jour de leur mort ou jusqu'au 7 janvier 1979.
Offer my apology to victims' families who were heartbroken because they had been living for 33 years without their beloved family members and have yet obtained justice.
Pardon aux familles des victimes qui, avec la perte des personnes qui leur étaient très chères, vivent avec des chagrins très douloureux depuis 33 ans et qui ne connaissaient pas encore la justice.
Correction, and I have not yet obtained justice. I admit that my suffering adds but a small amount of water to the great sea of suffering of the victims and their families.
Je sais que mes remords, si douloureux soient-ils, ne sont qu'une goutte d'eau dans un vaste et profond océan de misère très douloureuse des victimes et de leurs familles.
Allow me, Your Honors, who are seeking justice for the aforementioned individuals, to express my apology to all of them.
Je demande à Monsieur les co-juges d'instruction, Madame, Monsieur les co-procureurs, qui cherchent une justice pour toutes les personnes ci-dessus, de me permettre de leur demander pardon très modestement et avec des remords très douloureux.
I would like Your Honors to have this opportunity opened to me at all times. I would like to express my sincere thanks to Your Honors and that I have seen the survivors and that I would be able to express myself before the Cambodian people.
Est-ce que je peux avoir un commentaire en commentaire? Messieurs les co-juges d'instruction, Madame, Messieurs les co-procureurs, Messieurs, Mesdames ici présents.
Ladies and gentlemen here present, judges and co-prosecutors, this is what I wanted. This is what I want. What I want is freedom. Before, I was not free to speak out as I am doing now.
Donc, si une personne voudrait contester, il sera torturé avec
Because before, if a person wished to challenge what was being said, he would be tortured. I am thanking Duch for coming to give testimony before the court and for admitting his responsibility. I have no grudge against him. What I want is justice and peace for our country and for the million or so of our inhabitants who were killed. My only concern is that I would like him to speak the truth before the court, and I wish to thank him very much. Mr. Hu, Duch, does this remind you of important parts or important stages in these judicial proceedings? I think this reminds you of important times in your life. You heard that several victims are still not satisfied now when the trial is coming to a close. We also heard what the experts had to say. They have said that for the victims, it is a whole process, and the process has started. This will help them to reconstruct their lives, and this trial is a stage on the road to reconstruction. This brings me to my last question. Duch, do you authorize me to tell the victims that if they wish, they can come and see you in your prison cell, that you will open the door of your cell to them and the door to your soul? Do you authorize me to tell the victims that, Duch? Do you wish me to tell them that the road does not end today, and that the road that connects you and them remains open if they wish it to be so?
Response: I am much appreciated for that. Any victim who wishes to see me, I would be very happy to do so. You're all welcome. I opened the door to them emotionally, and most importantly, I would like to express my inner emotion of my feeling, of my guilt admission, so that they could see my true self. And I would like those victims to finally acknowledge that I finally accept my responsibility, that I admit my guilt. So regardless of who you are, as long as you are a victim, the door is always opened for you.
This is a play.
Monsieur le Président, je crois que nous sommes arrivés au terme.
Mr. President, I think we have come to the end, at least insofar as the questions to be put by the defense are concerned. Thank you.
The President, the questioning of the accused character has come to an end. And before we take a break, I would like to inform parties to the proceedings that for this afternoon session, the chamber will have a proceeding to receive any request for submission of additional material or documents which are not yet considered put before this chamber. And the chamber will consider those requests for additional submissions of documents this afternoon. And if the proceeding does not finish this afternoon, we will resume tomorrow morning again. And as the parties have been informed, the chamber already set the deadline for the submission of additional materials and documentary evidence, and the proceeding will start this afternoon. It is now appropriate for lunch break. Therefore, the chamber will adjourn and it will resume in the afternoon starting from 1:30. The hearing is now adjourned, and the security guard take the accused back to the detention facility and bring him back before 1:30 p.m. All rise, says the greffier. The President, please be seated. The chamber is now back in session. The President, next, the chamber would like to hear the submissions by various other parties to the proceedings regarding the documents requested by the Civil Party Group 1. Actually, there are two requests. The first one relating to the documents already placed in the case file and the new request for a new 18-page document. I wish to hear the comments from various parties. Defense Counsel, you take the floor. Thank you, Mr. President. The Defense Counsel believes the documents requested by the Civil Party Council Group 1, including those documents already placed in the case file, for that part, it shall not be granted because it's already in the case file, And if the civil party council believes any portion of those documents are crucial, then they should mention it in their final closing submission with the proper document identification, title, and EN number. That is my first observation. And my second observation regarding the newly found documents related to S21. As a principle, all the documents produced by S21 shall be submitted to the co-investigating judges during the investigation phase so that it can be examined and confrontation could be made. As some producers of the documents are still alive, and question could be put to those people before the co-investigating judges. Therefore, the defense counsel is not supporting this request. Thank you. The President, François Roux, you take the floor.
Thank you, Mr. President. Well, we are indeed very surprised, Mr. President, distinguished members of the court, surprised by these belated requests, and we see no link between these requests and the persons which our colleagues from group number 1 are asking. The confession of Ia, are the names of some of the clients quoted in these confessions? I thought that we had agreed that we couldn't use confessions, and if the name of one of your clients is not in such confessions, what is the point? What is the interest? Again, I observe, Mr. President, distinguished members of the court, that the civil parties are trying to become prosecutors. That's not their role. If the confession relates to one of their clients, then we can discuss it, even though this is all very late in the day. But the first question that we must ask is, does this connect to one of the clients you are defending? As for the totally new documents, here again, I wish to congratulate my colleague for her investigative skills, but I'm very sorry. I believe you're working with a non-governmental organization which has been dealing with this subject for many years, which regularly, since the outset of the trial, has been posting information on their website. And I remember, if you will recall the statement about the sentence to be applied to Duch, well, you have a solution that's being offered. It's an open and shut case for them. It's on their website. And so rather than making this kind of comment, I believe that that organization, which has been working on this issue for 10 years, would perhaps have been better inspired if they had gone to S21 to look for some documents. And similarly, I believe, I understand that the Office of the Co-Prosecutors began working in 2006, and I'm extremely surprised. 1 year of investigation by the co-prosecutors and nothing. 1 year of investigation of the investigating judges, nothing. Practically 1 year of trial, nothing. And on the last day of trial, then people come with a ream of paper and say, well, this is all important. And again, I ask, did you find in these reams of documents the names of the persons on whose behalf you speak? No. And once again, civil parties, you are behaving as if you were prosecutors. And every time that you're out of character, then you're taking the risk of drifting as happened with the victims last week. I'm sorry to have to say this again. I would like us to abandon this mode of operation personally. I regret. I praise the work that was done, but it's not your work to find paths and tracks and see the prosecutors and say, well, this is important for the entire case. Yes. To submit documents that have to do with your clients, yes. But at a time when the accused no longer has the time to enter into adversarial debate about these documents and can no longer comment, please don't bring a hair out of the hat, pull a hair out of the hat suddenly. We're here, and our presence here is all about justice and not entertainment. And so I am shocked, I must say it again, I'm shocked by this method of work, and I hope that you will take to heart the need to recall the minimal rules of procedure, and as I've said on many times, sworn enemy of what is arbitrary form is the twin sister of freedom or liberty. So we ask that these documents not be entered.
The President, Alain Wagner, you take the floor.
Monsieur le Président, puis-je répondre brièvement?
Mr. Werner, Mr. President, I would like to give a brief answer. Thank you.
Merci, Monsieur le Président.
Thank you, Mr. President.
Très brièvement sur la
Very briefly concerning the first request of my colleague. As you know, according to the internal rules, we are here to assist the co-prosecutors, and my colleague and we all consider that this is our task, and we feel that it is important that this document, which has already been filed, be put before the chamber. I don't see what damage it can do to the defense. With regard to the second observation of my colleague, I would like to say two things briefly. First of all, this is a thin ream. We're talking about 18 pages, not hundreds of pages. Second, to say that the defense is unable to respond is inaccurate, because today we are speaking about this precisely to enable the defense to speak. We are going to submit a document. Obviously, the defense will be in a position to respond, not at the hearing, but in writing. Therefore, the defense will have all the time in the world to reply to what we are going to submit. It will be submitted next week, and we will ask you to accept that these documents be put before the trial chamber. Perhaps I wasn't sufficiently convincing or clear, or maybe both, but it is our point of view, and I believe that it is an honest point of view to argue that above and beyond the great relevance of these documents will be of great importance to us in order for us to support our contention that you must not, in your judgment, exclude 4 of our civil parties. This is not at all a secondary matter for us. Now, a debate has unfolded throughout these hearings, and the defense, more specifically the accused, has constantly insisted on the fact that he did not recognize that such and such person was in S21 because the person's name is not on the list, and this was argued on numerous occasions. We developed our own arguments, but I believe that it's also our duty as counsel for these 4 clients. We also sought to find other means to convince you and to show that it isn't because the names of the relatives of these 4 clients cannot be found on that famous consolidated list of the Office of the Prosecutor that these 4 persons could not have been detained in S21. So, yes, I agree. It's quite clear that it is not the names of my 4 clients that is found in these lists. Nevertheless, it seems to me to be an argument in good faith to defend the idea that since the names of 14 people whose names are on these lists and who without any doubt died in S21 from illness, suicide, or torture, who are not in a consolidated list, and I think we can very honestly and in very good faith defend the idea that the relatives of our 4 clients in particular, and I can repeat their names if you wish, it is explainable that those names are not in the consolidated list, just as the list of the other 14 is not to be found there either. And again, we feel that it is important for our clients that these documents, above and beyond the relevance to the case, that these documents be accepted and put before the trial chamber. Thank you.
The President's Defense Counsel, you may respond.
Mr. President, no one is questioning the good faith of my opponents. It's not a question of good faith, and you know this full well. It's a point of law. It is possible that the persons you represent today had relatives in S21. That is possible. But you cannot defend an idea and its opposite. You had no cease, all of you, to attack Duch, stating that he was an extremely meticulous man. And now you're trying to say that there may be persons who were in S21 but were not on the list. That is not possible. A court can't conclude, well, these people were probably in S21. Dear colleagues, we're all lawyers, and you know that if we dare to open that door, there is no more justice to be done. And so I would like to ask you, if your clients in all good faith believe that members of their families were in S21, I am not challenging their good faith or yours. But when we are in a court of law, you know that we need to work on the basis of documents, particularly if you say that the accused was a person who spent all his time being meticulous and preparing documents. So, Mr. President, whatever the importance of the debate that is taking place, it is an interesting debate for a conference, perhaps. But before the bench, and the prosecutor repeated that earlier, it is necessary to rely on documents. So today, you are producing documents which tend to say that the accused is guilty. Well, don't waste your time. He said he's guilty. On the other hand, you're submitting documents where the names of your clients cannot be found. Thus, Mr. President, distinguished members of the court, in this case, I see no solution other than to say, if this can reassure the civil parties, please say in your judgment that these persons are certainly acting in good faith. But you must also remind them of the law, because one can also make mistakes in good faith, and we've seen it happen in this court, that people made mistakes in good faith. and it is not possible to make a mistaken decision. Thank you, Mr. President, members of the court.
The President, Judge Cartwright, you take the floor.
Thank you, Mr. President. On a less critical issue than those raised by the defence, can I just inquire a little more about the timing of the location and production of these this 18 pages of daily lists? As I understand it, you received a translation on the 26th of August last, after waiting for up to a week for a photocopy. Do I assume from that that you found the information about a week earlier? Secondly, from the 26th of August until today is approximately 3 weeks. Can you explain why this material was not put before the chamber while the evidence portion of the trial was being was still under discussion? Are you able to assist me with that, either Ms. T. Srinner or Mr. Werner?
Counsel T. Srinner, thank you, Your Honors. In relation to this matter, I would like to address to the bench that on the 26th of August 2009, it was the date we received those documents, because we spent some time before that seeking for those documents. When we received them, and then we spend some time to read and review, and we do the comparison to find the names of our clients and to check whether there is a relevance matter in those lists. And based on our finding, there were some many prisoners died in S21 whose names were not appeared on the smashing list, and it's just related to the number of prisoners at S21. For those who died, and it's only those who were taken for smashing that appear on the list of execution. And then we look further to find the kinship connection of the victim to our civil party or to our clients. And then we found some of the victims were end up at S21 without recorded in the list of S21. And in addition to that, the reason why we failed to request to put those documents before the court, because we have spent much time in a very busy work, and we were not allowed to request to put before the court at that time, and that we should wait until the hearing of the witness and the expert that proposed by the defense counsel. So we had to wait until the time until today. These are our problem and our obstacle preventing us from submission these documents earlier. President, please, you can take the floor.
I just saw that Judge Laverne may want to ask questions, so shall I address Her Honor Judge Cartwright? Just one thing more. First, there has been internal discussion within our team to try to understand the scope and the importance of the documents. Secondly, there has been discussion with the prosecutor, the Office of the Prosecutor, because indeed we wanted to make sure that it was not document they had within their office without being in the case file, or it was not document that somehow we have missed in the case file. So there were discussions with the Office of the Co-Prosecutors. And finally, as you know, in the last 3-4 weeks, there were civil parties in court, and then there was a discussion on the character of the accused and your decision that for some parts we were not allowed to take part. We didn't see any opportunity at that stage for us to intervene in view of the fact that Rule 87.4 said that during the trial, either on its own initiative or at the request of a party, the Chamber may summon, hear any person as a witness, or admit any new evidence. So we thought that under 87.4 we could file something until the end of the trial, which does not mean end of the hearings, but end of the trial. So we thought that we were still within the time imposed by 87.4 to file that motion. And when we understood that there would be discussions today, then we decided to show this morning or yesterday the exhibits to the Defense Counsel and to orally make the argument in front of Your Honor. So that's the best we can provide as explanation at that stage.
President, Judge Lowen, you can take the floor.
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. President. Well, we've now heard one party. I'd like to know if the co-prosecutors were made aware of the documents which the civil parties would like to see put before the trial chamber, and if they have an opinion concerning this request, and whether they think that these documents will be useful in ascertaining the truth.
Your Honors, a meeting was sought by the civil party concerned with the Office of the Co-Prosecutors. In that meeting, which I attended along with one colleague, we told the learned counsel that it may be a relevant document. It may refer to matters at issue at this trial, yet the considerations under 87.4, where due diligence has to be demonstrated for this document to be adopted or accepted by this court, should be met. So we said that, of course, it's up to you to tender this document, and we shall take a position accordingly. And because the document is relevant, and because the civil parties, given their limited resources, have brought them before you, we shall take no position on this matter, Your Honors.
The President, yes, you may take the floor, Mr. Francois.
Mr. President, Your Honors, it goes without saying that if these documents were to be put before the trial chamber, you would have to reopen the proceedings so that the accused may be afforded the opportunity to comment on these documents. But, excuse me, I'm sorry, but I'm flabbergasted. We have all been working hard to ensure that there are no delays in the trial. And what you're asking for is an extension of a time limit? And you're dealing with an accused who said that he admits everything. And you're referring to documents that do not go to proof of added guilt, and documents that do not actually emanate from your clients. This is not my view of how justice should be done. But let's go on. We could do this on the 25th of December. That might be a good day to do this.
Yeah, no, can I answer in one word?
The President, now please make sure, so how many times would you like to take the floor? So in this case, how long and the time that you need so that we can save some time? And if you raise so many remarks, it may take a long time. So could you tell me how many times you need to talk before you come into your conclusion?
Monsieur le Président, avec respect, mais
Mr. Werner, Mr. President, with all due respect, your chamber asked the co-prosecutor to make a statement with regard to this application. The prosecutor spoke, the defense was allowed to speak again, and there are other points that I think it is fair for me to raise. I think it is normal for me to wish to respond to what Mr. Hu has just said.
The President, I do not understand what you just said, because we seem to argue on the document, but it seems to me now you have the agreement between the co-prosecutor and the defense counsel from Swaru. So could you please mention the matter again, and then we can leave some time for other civil party councils to make their address and submission, and then we can conclude this matter for tomorrow, and then we can schedule for the next day or the next weeks to continue the hearing, so that we can use for the new document or the document to be submitted, and then we can make the assessment of time for the trial chamber to make a ruling on that, so that we can come into conclusion for the date for the final submission that we have specified.
Mr. Werner, I shall be very brief. First, obviously, I've said this several times, we consider that these documents have something to contribute. Secondly, if Mr. Hu is saying that his documents have no value, then they're not prejudicial to the defense. And I think under 87.4, it is perfectly possible for the defense to respond in writing, and the accused can respond through his lawyers when they will have perused the documents. Mr. President, with all due respect, the prosecutors have not taken a position. They are neither in agreement with the defense nor with the civil parties. They have not taken a position. Thank you.
The President, Judge Jean-Marc, you may take the floor.
Merci, Monsieur le Président.
Judge Lavergne. Thank you, Mr. President. I would just like us to return to a matter that was raised by the defense a while ago. This is with regard to the summary in French of the documents that the co-prosecutors wish to put before the court, and these documents pertain to the armed conflict. What I would like to know from the co-prosecutors is whether the summaries of each document severally attached to their document was sent for translation into French. I would like to know if this is not the case. I will have a question for the defense afterwards, but first I should like the prosecution to answer this question first. Is there a pending request for translation of the list of documents which have been put before the chamber with regard to the armed conflict?
Your Honours, on the 29th of April 2009, when we filed our annexes to the armed conflict documents, which run into some pages with detailed summary of each document, it was filed in the two languages that the Office of the Co-Prosecutor has chosen under the practice directions. Once they have been filed in the two languages that the Office of the Co-Prosecutor has chosen, then it's for the court management section to translate them in the language of the other parties. Now, at this stage, I cannot assist Your Honours whether this is under translation, but I shall be able to assist the first thing tomorrow morning whether it is under translation as requested by Your Honours or the court management section. But we filed in the two languages, which is English and Khmer, which are the languages that the Office of the Co-Prosecutor has chosen under the practice directions of filing of documents. However, now that I have the floor, just one more minute to add that a number of these documents, and I can give figures should I have time, are also the documents themselves, not just the summary, in more than one official language of this court. There are 430 documents, more than 200 are at least in two languages. So I can assist you further, but in respect of the annexes, I'll be able to assist first thing tomorrow morning.
Merci. Donc,
Judge Lavergne.
nous écouterons avec intérêt donc ces précisions
Thank you.
demain.
We await these clarifications tomorrow with bated breath. I shall now move on to the defense. I seemed to understand that the co-prosecutors made a proposal with regard to confessions which are supposed to be supporting the annotations of the accused. The proposal was that you should meet and discuss which of those documents could be admitted and by both parties and be put before the chamber. So what I would like to know is whether the defense will accept this proposal or has accepted it, and I would like to know the exact position on of the defense in regard to this matter. Mr. Ho, thank you, Your Honor. For once, I shall be extremely inflexible. I will tell the chamber that we consider that we've had a lot of time discussing matters with the Office of the Co-Prosecutors, and this time has so far proven to be useless. I will not spend more time on this. If the Office of the Co-Prosecutors were to the Office of the Co-Prosecutors offered, in order to save me time, to verify these documents that they would put before the court. So, for my part, I am not going further than that. We've had 3 months of discussion on the admitted facts, day and night, for nothing.
The President, please, Mr. Co-Prosecutor, you may take the floor.
Your Honors, I don't mean to make it endless, but just to conclude in response to what my learned friend observed. This matter before you right now in respect of annotated documents has got nothing to do with agreed facts. Therefore, my respectful submission in light of the acceptance of other documents by my learned friend was that we can consider with my learned friend, should he wish to evaluate such documents that he may agree to accept. In the absence of such agreement, as I now see that is the case, we would press that these documents be taken on record and considered put before the chamber on the basis of our application. Just to add that we have removed from this list such documents that were put before your chamber and have been granted an E3 number. Now, I must respectfully submit that there is a delay in our receipt of E3 numbers. Therefore, such documents that were put before you, which have not yet been granted E3 numbers, find a mention in this annex, but those who have already been granted E3 numbers have been removed from this list. And one last request on this E3 number issue, Your Honors, we would most respectfully submit that an E3 number be granted to a complete document and not 1 or 2 relevant pages that were discussed in the chamber. That may assist you in your final analysis when you deliberate on judgment to have the complete document before you. And should there be an appeal, it should be helpful for an appeals chamber to deliberate on the basis of the complete document. And in that view of our matter, our submission would be that all those documents whose ERNs have been read before you in your chamber should be granted E3 status, because we should be sure what we should include in our closing submissions, which are due very, very shortly, Your Honors. That's my limited submission. Thank you.
The President, you may take the floor, Mr. Counsel.
Mr. Hu, just a point of order. I am not responding. I have already said what I wanted to say, but just a point of order. I asked that all the documents that will be put before the court should be placed on the court's website. But for confessions, I think it is not possible for us to put them on the site. This is out of respect for the victims. So we should pay close attention. When perhaps the annotations of Duch will have been discussed in court, the first page of the confessions can be placed on the website. I think that if we are to respect the memory of the victims, I think it will require us not to put the full confessions on the website. I just wanted to draw attention to this point. For other matters, I rest my case. I think that only the confessions that have been publicly discussed in proceedings should be put before the court.
អង្គជំនុំជម្រះរបស់យើងសូមអរគុណ
The President, Judge Lowen, you may take the floor.
Oui, Monsieur le Président.
Judge Lavin. Mr. President, a last question for the co-prosecutor. We understand that you want the trial to be expeditious. We have a question to put to you. Of the 60 documents that purportedly contain annotations made by the accused in his own hand, do you intend to put the documents before the court, including those that have not been discussed adversarially? Or do you expect to limit the documents you will tender to documents that have been the subject of adversarial debate? If that is the case, then there is a problem, because the defense should be afforded the opportunity to make submissions on the documents that have not been the subject of an adversarial discussion so far. So, what we would like to know is whether the Office of the Co-Prosecutors will agree to limit its request to put documents before the Chamber to documents that have already been discussed adversarially during the proceedings. Bearing in mind that a while ago the defense referred to documents produced at the request of the co-prosecutors, but it seems to me they are documents which were shown to the accused by the accused himself, by the chamber itself, and sometimes by some civil parties.
Your Honours, I have an answer, but subject to Your Honours' leave, if Your Honours are minded to adjourn for the day, I will give you a very considered response in the morning, keeping in mind a very serious observation made by His Honour Judge Laverne. But should that not be the case, I'm happy to respond. But I'd be very respectfully submitting that Your Honours may allow me first thing in the morning to make observation on this, and we shall try, should it be possible, to discuss it with defense overnight to come to a conclusion. Otherwise, I'll make my observations the first thing tomorrow morning. If Your Honours are not adjourning, I shall give my tentative response.
Juste une dernière question à la défense pour
Judge Laverne, one last question for the defense for scheduling purposes. Will the defense have other documents to put before the court? This is for information purposes only. Mr. Ho, the chamber has our list of documents that had already been submitted under D80. At the commencement of trial, under E59, we put a number of documents before the court. These documents are mainly books and video footage, in addition to other written documents pertaining to the Obrenović case. We have one last document, however, which is quite new. This is the record of an interview that was given by civil party Chum Mei to a French newspaper, and we did not wish to put the documents before the court until we had asked to see the video that we saw today, and now we would wish to put this document before the court. This is the only new document. All the other documents have been made public. It shouldn't take a lot of time.
The President, now it is time for the trial chamber to adjourn its afternoon session, because we could not finish today because there are 3 groups of civil party lawyers who intend to make the request, because we spend more time for the prosecutor and the defense to provide the arguments. And the trial chamber is declared adjourned for today, and we will come back to session tomorrow at 9 o'clock. And the security official is instructed to take the accused to the detention facility and bring him back tomorrow before 9 o'clock.
Au centre de détention et de le ramener dans cette enceinte d'ici 9 h demain matin.